May your Lordship, Lordship, I beg to mention item number 2. Your Lordship, conducting counsel, Mr. Disoki is out of station on medical urgency. So I have been instructed to fix this matter on Wednesday, next Wednesday, on 7th.
Mention is made on behalf of Mr. D. Soke, learned counsel for the petitioner for adjournment of the matter since the learned conducting counsel is out of station. In view of the above, as prayed for, list on 7/8. 2020. Yes.
Apply. Item number 30.
30.
Yes, 30. That may be adjourned for a week.
Okay.
Supplementary hearing.
Mr. So-and-so, learned counsel for the appellant has prayed for adjournment of the matter. In view of the above, list after
After a week.
1 week. Yes. On a date fixed by the registry.
May I please, Your Lordship? Your Lordship, I beg to mention item number 12. On behalf of R.L. Tungon, he is out of station, so matter may be fixed next week, Your Lordship.
Okay, mention is made on behalf of Mr. R.L. Thompson, learned counsel for the petitioner for adjournment of the matter since the learned counsel is out of station. In view of the above, list after,
Next week, Your Lordship.
list in the next week. Yes.
Deeply appreciated.
My lord, I beg to mention one matter for taking up tomorrow, my lord.
What is it?
My lord, I beg to mention one matter for listing of tomorrow, my lord.
What matter? What type?
This is quashing petition, my lord, criminal quashing petition, my lord.
482.
Yes, my lord. For tomorrow, my lord, if my lord can accommodate, my lord.
You see, usually criminal matters are put up before the courtroom number 2. I mean, that is the usual practice, even in the principal seat. So have you made an attempt?
No, my lord.
Then go to courtroom number 2 in case the learned sitting judge has some problem and then he refers the matter here, it's okay. Okay,
My lord.
that's the usual system.
Your Lordship, Your Lordship, I have to make mention item number 24. I would like to
24.
withdraw this matter with liberty.
Item number
24.
24. Yes. Adjournment.
No, Your Lordship, withdraw the matter with liberty. Withdraw the matter.
Yes, adjournment.
liberty.
That's what I'm saying, isn't it? You're appearing on behalf of
K. Lolin. K. Lolin.
K. Lolin. Okay. Mention is made on behalf of Mr. K. Lolin, learned counsel for the petitioner for adjournment of the matter. Why? Where's he?
Not adjournment, withdraw the matter with liberty.
Withdraw.
Yes.
Okay, why? Why?
Because the clients don't want to pursue the
Okay. Your good name, Miss?
M. Sora.
Okay, your name is also here.
Yes.
Miss M. Sora, learned counsel for the petitioner, submits that they wish to withdraw the instant writ petition since the petitioners no longer wish to pursue the matter. In view of the above, writ petition number 113/2024 stands disposed on withdrawal. Yes,
Obliged.
disposed of. Okay, disposed of on withdrawal. Yes.
Yeah, here for item number 7, 26, 29, 31, and 32.
Speak on the mic. I have to. Item number 7.
27,
27, then 27
29,
and 29.
31, and 32.
28, 29, 31 and
32. And
32.
item number 7,
You're appearing on behalf of
D. Panging.
T. Tamung.
D. Panging
Okay.
for adjournment.
Counsel for?
D. Panging.
He's the counsel for?
Sorry,
Okay. It's D. Panging.
D. Panging.
Okay. Sometimes he's counsel for the petitioner, sometimes for the respondent. So mention is made on behalf of Mr. D. Panging, learned counsel. Then look at the cases. Okay, in some he is the petitioner, in some the respondent. So you'll have to check the files. since the learned counsel is said to be out of station. In view of the above, list after 2 weeks.
Thank you.
May I please, my lord? My lord, I beg to mention item number 22, man.
Yes.
My lord, it should be,
Here again, there's Mr. D. Panging.
Yes, your lordship.
madam.
Actually, your lordship,
Taken after job.
this matter was listed for consideration of suspension of sentence. But however, your lordship, paper book, everything is prepared. So let this matter be listed for final disposal after 3 weeks, your lordship. Other side, the victim side service is also completed and they are appearing, not today, but your lordship, they appeared on the last occasion also. So let's
Now,
put,
you are for Mr.
I'm appearing on behalf of Deep Angin, man.
So, let Mr. D. Panging also this thing, and then let's see whether okay. Mention is made on behalf of Mr. D. Panging, learned counsel for the applicant / appellant for adjournment of the matter since the learned counsel is said to be out of station. Mr. So and so learned PP,
I'm additional PPT at the additional PP, your lordship.
additional PP.
Yes, your lordship.
For the state respondents submits that in the instant case, since paper book is ready and duly furnished to both the parties. What's the case about?
My lord, this
POXO
is
case, your lordship.
POXO.
So where's respondent number 2?
Respondent, your lordship, today they didn't appear, your lordship.
They have already filed their wakalatnama, my lord.
Okay, so paper book been furnished to them
Yes, your lordship.
Yes, madam.
and submits that paper book has been duly furnished to both the parties. The learned counsel therefore submits that the instant pending IA may be considered along with the criminal appeal for hearing in the next appropriate date. In view of the above, matter may be listed for hearing
Yes, ma'am. After 3 weeks.
after
After 3 weeks, ma'am.
3 weeks.
Yes.
You should be the one in a hurry. Your IA is also going to be heard with that,
Yes, yes, ma'am.
but it's POXO, so leave it. Okay,
Yes.
after 3 weeks on a date to be fixed by the registry. Yes.
Deeply
Okay.
obliged, your lordship.
Mayor Lordship. Lordship, I would like to mention item number 8.
Eight.
I'm for the petitioner.
Oh,
The LCR record is also there. Lordship, this matter may be taken up next week for fixed date 6th of
Okay.
August.
on the submission made by the learned counsel for the petitioner. List this matter on
6th of August.
6/8/20.
My lord, I beg to mention item number 21. With the consent of the petitioner, my lord, this matter list after 3 weeks, my lord.
Okay, Mr.
P. Tagum for rest,
T. Taran, learned counsel.
standing counsel for education
Learned
department.
standing counsel for education department submits that this matter may be listed
After 3 weeks,
after 3 weeks.
my lord.
3 weeks, and that the consent of the petitioners have also been taken. Counsel for the petitioners have also been taken. In view of the above, list this matter after 3 weeks.
My lord.
Yes,
Kind indulgence to item 33, my lord.
33.
Sir, 33 supplementary here.
Yes,
After 3 weeks, my lord.
okay. Mr.
I have objection, my lord. My lord, this matter is keep pending for last since 2017, my lord. So, my lord, this may be hard today, my lord.
What is the matter about?
My lord, this is let this be.
It's okay, my lord, because it will take some time and it is in the last, it is as a last item.
We'll list
there-
on Monday.
If there is any objection, I am ready now. Today also I'll argue, no problem.
We'll list it on
My brother
Monday.
is,
Short date on Monday.
my brother saw some urgency. My lord,
Okay.
let it be in the list. I'll argue.
Okay, in the next date, isn't it?
No, today also I'll argue. Well, my brother has expressed some.
See, is it a simple matter or a complicated case?
It will
That's
take,
one thing, because this bench will not be sitting
My lord,
day after tomorrow, from day after tomorrow.
not that much complicated, my lord.
it is a complicated matter because it went, so many things to be right.
Okay, so
If
we'll
I
look at
introduce-
Monday, so that in case it has to be list it again and the next day or
My lord,
something?
fine, let it be in the list. Let him come and argue.
Okay.
We'll argue.
We'll see, okay, because this court is not very inclined to take up matters which need later a lot of what, for the judgments time, okay. You see, because the moment we go to another bench, our mind switches off from this bench and it goes to the other bench. Then CABs take a little bit of time, that's the only thing. So what is the urgency in the matter?
My lord, actually, my lord, first, my lord, in 2017, my lord, petitioner has filed second appeal, my lord. After obtaining interim order, this matter was kept pending for 6 years, my lord. In 2023, it was withdrawn, my lord, by
Huh.
petitioner.
Huh.
Thereafter, again, they have filed repetition. That was withdrawn, man. Now this CRP is in file.
Okay, so what are you suffering right now because of this? Can we adjourn it for Monday,
Okay, my lord.
Monday, I will-
Tuesday?
any date after 7 or 8. That's
Tuesday
right.
will be filed, my lord.
Pardon?
You cannot dictate the court that way, Puja.
No, no, no.
When you have
No,
objected, I think
I
I'm
am
hearing today.
I'm concerned because if adjournments are there, as the, one of the parties
No, no, my lord,
needs to
since
suffer.
my brother, he has
Huh,
raised the
huh,
objection,
huh,
I want to hear it today.
huh.
And he is saying that on Tuesday. So one cannot be that harsh in such kind of mancining. At least one should have some courtesy.
Okay, let's see if we can hear it
Huh.
today. Okay, then depending on
there
how
is
it
really
goes about,
urgency,
we will
let him-
adjourn.
Because I don't
Yes,
have any
yes,
issue.
Yes.
But I
Okay.
thought ki since my lord was not taking up the hearing matter
Hmm.
for paucity of time and writing judgment.
Yes.
Then I thought of
But
that.
if it is a simple matter, we can dispose it off
Yes,
in the court. I can give dictation.
No, no issue.
Leave it. Yes,
Yeah, please, Lordship. Lordship, I beg to mention item number 17
what 7?
on behalf of Mr. O Modi, leading counsel for the respondent number 4. As he's out of station, so
I'm for a petitioner. I have no objection.
Okay. On the submission made on behalf of Mr.
O Modi, Lordship.
or Modi for adjournment of the matter, which is not objected by Mr.
She Modi.
Sri Modi, learned counsel for the petitioner. Is this matter on
After she.
after 3 weeks on a date to be fixed by the registry? Yes.
My lord, I may be allowed to withdraw the matter, madam.
Withdraw.
Yes, my lord. With liberty, my lord.
Heard Mr. Fivanso, learned counsel for the petitioner, who submits that he may be allowed to withdraw the instant. Okay, whether it's compoundable or not.
Yes,
that's
ma'am.
what, on instant petition with the permission, okay, with since he wishes to approach the right forum, is it?
My lord.
The corrupt forum in this matter. Accordingly, the state criminal petition stands disposed of on withdrawal. Yes.
And liberty, my lord, in case he will not get relief in the lower forum, my lord, in the appropriate court, my lord.
Okay, with a liberty to file the state matter before the appropriate forum. Yes.
Oblige me.
Yes.
Sorry, my lord.
Huh.
I thought they are going to call item number 2. My lord, in this writ petition, I am challenging the seniority list, my lord. Earlier, my lord,
Hmm.
I had filed a writ petition challenging the promotion given to me, not with retrospective effect, but from the date of the DPC. Whereas, my lord, I have been working in officiating capacity and since 2007, there are 3 petitions actually. Petition number 1 was working since 2005. Petition number 2 and 3 were working since 2007. In 2009, they were also given pay scale of the higher post with officiating promotion. That is specifically dated 4/2/2009. But Lordship, DPC was not held for a very, very long time. The last DPC that was held was in 2012. That time they were not considered. As per the RR, they are more than eligible because the RR says 8 years of qualifying service as junior engineer for diploma holders, and for degree holders, it is 5 years. So since the petitioners are degree holders, they have qualified long time back. So, but when the DPC was held, that is on 31/10/2019, they were given promotion only from the date of the DPC. That is 31/10/2019. So therefore, several representations were made, and the government had decided to conduct a subcommittee on that. And subcommittee report was also in our favor. But the government, instead of taking into account our representations, the subcommittee report said that taking all these things into account, into account that DPCs were not held within time, so these things may be looked into before proceeding further.
And let's see the subcommittee
Yes.
recommendation,
Yes, Lordship.
the report.
Yes. Page 70, Lordship.
Relevant portion, decision.
Relevant portion would be the last one, Lordship. Page 75. After discussing all these things, the subcommittee report says, so the total post of assistant engineer is 48, and each line promotion will get 24 posts to the and the direct recruits will get 24 posts each as per the revenue. As per the above statement, the department had filled up 24 vacant posts of assistant engineer. Being officiating vacancies, the committee has been informed that the department had never conducted departmental promotion committee meeting and going on filling up the posts of chief engineer, superintending engineer, executive engineer, and assistant engineer on officiating basis only. Therefore, the claims and objections and counterclaims had occurred. The above table had been filled up, leaving 50% for direct recruitment quota from 2005 to till date. Therefore, the committee is of the opinion that the appointing authority should dispose of the representation submitted by the promotees and the direct recruit, if any, and finalize the relative seniority of direct recruits and promotee as under general principles of seniority. The relative seniority of direct recruits and promotees shall be determined according to rotation of vacancies between direct recruits and promotees, which shall be based on the quotas of vacancies reserved for direct recruitment and promotion respectively in the recruitment rules. So before finalizing the seniority, they were supposed to look into the representations of both the sides. This was never done. Instead, they published final seniority.
One thing, when they were promoted on official basis.
Officiating basis, Lordship. In case of
Was there a vacancy to the post? No.
at that time there was a vacancy.
There was
a vacancy.
But
Still they were, not only them, the whole department, in fact, officiating promotion only, as it has been observed.
Though there were vacancies.
Yes, yes.
Okay.
So that was the case before, that is the case before this Honorable Court in WPC 14, which I have filed. During the pendency of that case, they have finalized the seniority without considering all these aspects. We have also, after they published the provisional seniority list, we have also made representations to this effect. Kindly dispose of our representation, kindly do a review DPC, as we have prayed for in the read petition 14, that is still pending. But in spite of that, they have finalized the seniority. And after finalizing the seniority, now they have on 11th of July, there was an order for constitution of a DPC, probably based on this seniority to promote some officers. But that DPC did not occur.
In the seniority.
Yes.
What your official officiating a promotion.
Yes.
Was not considered?
No, was not considered. Was not considered. Therefore, we have filed WPC 14 of 23, which is still pending before this Honorable Court. In the meantime, despite this subcommittee report and despite our representations against the provisional seniority list, the final seniority was published. But in the final seniority list, your Lordship will see at page 112, in the last portion.
Yes.
In the last portion, Lordship will see note, there is a note. The
Yes.
seniority position of Sri Yimi Ango now officiating as E at serial number 12 shall be subject to the outcome of the Honorable Guwahati High Court, Itanagar Permanent Bench in case number this, and we are not concerned with this. And as regards, your lordship will see, as regards serial number 41, 42, 44, 45, and 47 will remain the same.
You're
Unless-
the petitioners here.
Yes, 44, 45, and 48.
Okay.
But I think 48 is a typing mistake because 48, the person with serial number 48 never made any representations, nor he has filed any writ petition. Yeah, petitioner number 1 is at serial number 44, number 2 is at page, serial number 45, and number 3 is a serial number 48. Will remain the same until unless the authority of the government considers the request for promotion with retrospective retrospective of officiating promotions or any other orders comes from the Honorable High Court. So this is conditional. They have mentioned this, but still in the next page, your lordship will see, this is an order for constitution of a departmental promotion committee for promotion. This is 11 July 2024 to examine the promotion from number 1 superintending engineer to chief engineer. This we are not concerned. We are concerned with number 2, assistant engineer to executive engineer. And other things under the Department of Power, under the Department of Hydropower Development and chairmanship of this and this. But DPC was to be conducted on 19th of July, but this was not conducted for maybe some administrative reasons. Now what we are concerned with is, lordship, they have not disposed of a representation. In the writ petition is also still pending. Then they have, even though they have made the final seniority list, that is still conditional because they have left some window open saying that this will be subject to certain orders if it comes. But in spite of that, they are now trying to promote. Obviously, if the promotion is done, then it will not be us because our serial are quite below. Yes.
Your promotion is made effective from 31/10.
Yes, 31/10/2009. I may also add, lordship, that in the department there are different wings. This is of engineers of civil wing. In electrical wing, also recently, I have not brought that, but recently they have made promotions giving retrospective effect. Unlike us, they are giving different treatments. What I'm trying to say is that, of course, will be subject matter of the WPC 14, which we have filed already before this honorable court. Now, lordship, if this is acted upon, this seniority list is acted upon, then it may be too late for us. The matter may become infructuous, whereas all our grievances are still pending.
But this is also provisional, isn't it? The seniority list, it's subject.
No,
to
it's
the
final.
outcome.
This is a final seniority list, but they have mentioned like
It's
this.
subject to the outcome.
Yes, yes.
So there's no need to interfere with that because.
No,
then
lordship, but-
These subject to the outcome of that pending WPC.
Yes,
Now
but
that WPC and this, maybe they have to be listed together or.
yes, they have to be
not
listed
how?
together. But in the meantime, lordship, after giving this also, after making this conditional also, they have issued this order, the last order for DPC, lordship. So if the DPC is conducted, obviously the seniority list will be taken into account. And this seniority list is in this seniority list, obviously we are placed much junior. Lordship will see how the seniority list has been prepared. People who were appointed in 2007, 2009, they are made senior to us. Whereas and people who have joined the service in 2011, 2012, they are also made senior to us. It is a settled law that a seniority can be counted from the date a person is born in service. Suppose we ignore 2007, 2009 also. Then in 2012 also people are made senior to us.
See, this order you're mentioning.
Yes.
Which is at 113.
Yes,
It is to examine the promotion.
yes,
PC sitting for the promotion to the post of the present one, isn't it?
yes,
Number 2, assistant engineer.
yes. We are concerned with assistant engineer.
Oh.
Assistant engineer to executive engineer. Since the senior list is of assistant engineer, if they give promotion, it will be on the basis of this seniority list. So my prayer today is that this further promotion may not be given on the basis of this seniority list, and this writ petition may be listed along with WPC 14 of 22.
Wait, huh? Now, you have already been promoted as assistant engineer.
Yes,
But the only problem is the effective date.
Yes.
That is your main thing.
Yes,
Isn't it? The
yes.
effective date should be this. So how is your case to be connected with a holding of a GPC for assistant?
Because-
engineer
because,
when you've
Lordship-
Already been promoted. Your case, you have
No, no,
already been
no.
promoted.
This, the promotion is of assistant engineer. Now they are going to hold promotions from assistant engineer to executive engineer, executive engineer.
Okay,
Ah,
okay.
so
Yes, yes.
since-
You feel that you are also eligible to be promoted as.
Much more than eligible, in fact. So that is why.
Okay, yes. Will issue notice? Heard Miss Dangan, isn't it?
Yes, and
Learned
Duncan.
counsel- Learned counsel for the petitioner. Full stop. The instant application / writ petition is filed under section 226 of the Constitution of India, filed under 226, okay? Is for issuance of the appropriate writ or direction to the respondents wherein the instant writ petition is challenging the validity and legality of the impugned inter-seniority list of assistant engineers issued by order dated 29 July 2022. The learned counsel submits that the petitioners wide order dated 29/08/2027 were given promotion to the post of assistant engineer on officiating basis and have also been given pay to the post of assistant engineer since their appointment as officiating promotion. However, the DPC held on 31/10/2019 regularized their promotion to assistant engineer with effect from the date of the DPC, that is 31/10/2019. Because of this, their seniority has been effected in the seniority list, impugned seniority list. Issue notice to the state respondents.
Respondent number 1.
Ms. So-and-so accepts notice on behalf of government advocate, okay, on behalf of the state respondents. Notice is to be issued to the private respondents, is it? Through registered post with AD within 3 days, returnable by 3 weeks, less after 3 weeks. Full stop. Then Miss requisite extra copies of the writ petition to be duly furnished to the learned government advocate. Full stop. Then Miss Dangan further submits that the DPC to be held with regards to the examination of promotion from the post of assistant engineer to assistant engineer within bracket C to executive engineer within bracket C.
On the basis of the seniority list dated
Okay.
29 July.
On the basis of the impugned seniority list, may be stayed till the disposal of the instant writ appeal along with a connected writ appeal.
WPC 14
W.
of 2022.
14 of 2022. She further submits that since the instant matter is connected with the said WPC 14 2022, both the matters may be listed together. In view of the above submissions, this court find it fit that the state respondents are not to conduct a DPC with respect to the promotion to the post of assistant engineer within bracket C to executive engineer within bracket C. Based on the impugned seniority list dated
29 July 2022.
29 July 2022. Till when we say disposal, till the next date. Okay, we'll pass an interim, then we'll keep continuing because we'll have to hear the other parties.
Till the returnable date.
Till the next returnable date. Yes.
Oblige.
And date and this matter is to be listed along with the pending WPC 14/2022.
Oblige.
Yes,
Pleasure.
yes.
My lord, the brief facts before the lordships. Here, my lord, I am active members working dedicatedly for the my lord, political party of the BJP for last many decades. As a result, my lord, by virtue of my activeness in the party, I was
Which party?
elected uncontested in the years 2022 as a GPM. In the meantime, my lord, I have been wholeheartedly service for the
Okay,
interest of the
BJP,
party.
huh? Yes.
So,
Huh.
my lord, in due course of the time, my lord, there was the relation between me and the respondent number 4 was not good. It is only because that I am very much active, and perhaps what happened, my lord, that I cannot say that the respondent number 4 having not good relation with me. In the meantime, my lord, may kindly come to page number 18, that this letter has been surprised me. Page number 18, my lord. My lord, got it, annexure D. This is the person, and my lord, my name is in the serial number 6. I am not concerned with the, not concerned with other, I am concerned with serial number 6 only, my lord. GPM, Tigdo 3, UPI Tigdo Gram Panchayat, my lord. So, my lord,
This is within a political party, isn't it?
Ma'am.
JP.
so, my lord,
So you must be having some constitution for
The-
your party.
definitely, my lord. Therefore, what the party, political party constitution say that, my lord, at least to be terminated from the party, my lord, there should be a show cause notice. At least I should be informed what I have done, my lord, and there should be a complaint from the other party, my lord. But without doing this has been, my lord, surprised me to include in those person to be, my lord, terminated. So on my query to the respondent number 4, why, my lord, without any reason and without show cause notice, I have been surprised by the termination. So, my lord, may kindly come to page number 7. Specifically, I mentioned in para 11. The reason pretext taken by the respondent
So
number,
your constitution, have you enclosed the constitution of the party?
my lord?
Have you enclosed?
No, my lord.
Then enclose
I
that
have not entered.
where the notice has to be issued. Then if this is within the state or within the district, state,
State.
then is there any provision if they're unhappy with the state, there is a way of addressing their grievance before maybe another regional political party, something like that? So please enclose the constitution.
Exactly, my lord. What I am trying to
Huh,
point
huh.
out that, my lord, that no any document, my lord.
Hmm.
There should be a complaint. There should be any other document.
But do you have your this thing, enclose your constitution, the party constitution
My lord,
first here,
but I-
okay? Please do that and then we'll list it again.
My lord.
That's, it's very incomplete, you know? Yes. Heard Mr. So-and-so,
So-
learned counsel
So,
for the
my lord, may I
petitioner.
complete, man.
Yes,
I may be allowed to complain, man. In due course of that, my lord, what they have taken the pretext that there has been a letter submitted before the SDO on, my lord,
hmm,
22 March 24.
okay. Ah,
Then when I come to ascertain from the SDO office, my lord, this was submitted on 5 April 2024.
hmm,
Before submit the complaint against me at the SDO office, my lord, this termination was made.
hmm.
So in view of this termination order, my lord, the show cause notice was issued to me and it's appear in
So
page
your
number.
first notice was
Yes.
issued
This-
after that, huh?
This is the first termination. I ought
No
to
show
pay the
cause
show cause notice in
first.
the first
Second,
termination.
there's show
Yes.
cause, okay.
And accordingly, I replied that the show cause notice.
Hmm.
But this, so what is procedure is, my lord, in view of my show cause notice, I should be hard man. I should be allowed to appear before the concerned officer to pass. And I should also given an opportunity to reply to my lord allegation. Here, my lord, I am in dark. Who are the person against me and where is the any complaint against me? So, my lord, the principle of the audio alternate party, my lord, by hearing opportunity of the party has been violated, my without giving me an opportunity to hearing why I should be terminated. That hearing was not conducted, and
Okay.
instead for what, my lord, I have been terminated, disqualified. So, my lord, in page number 24,
Hmm.
this is the again the impugn order, my. So by this order, the place where I have been appointed, I have been disqualified by the order dated 22 July 24. Out of this, my lord, my place has been vacant declared. So, my lord, at this stage, my prayer before the lordship is that let the notice be issued and let the annexure D and the annexure H be stayed. Otherwise, my lord, if further notification is made from the election commissioner, my lord, I will be very much, my lord, irreparable loss will be cast to me, my lord. So without
wait,
giving me and establish my case, without hearing me, without giving me an opportunity, this, my lord, disqualification has been made.
So if this notice is from the district election officer, shouldn't you approach the
My
trade?
lord, that not so far this has not done, my lord. So this is
So your grievance,
this
shouldn't it be placed before the state election
No, ma'am.
officer?
so far this, my lord, under this law, this
Which law?
Arunachal Pradesh Local Authorities Prohibition of Defection Acts
Huh.
2003 is concerned, my lord. The order passed in the capacity of the deputy commissioner. He is the, my lord, final
the-
authority.
Okay,
Yes, as a district election officer.
so
Yeah.
let's see the provision of defection, whether if you're unhappy with this, is there a provision to approach the state?
There is no, my lord, my submission would be, there is no other provision, ma'am, other than this deputy commissioner. So only the next stage is before this lordship. And my lord, the various cases has been come up before the honorable court,
Hmm.
in the same matter that nowadays, my lord, this type of this writ petition are very common before this honorable court.
Hmm.
In view of the order
Maybe
passed by the
issue
deputy
notice
commissioner.
first, let them, let's see.
Right.
Isn't it?
My lord, at least, my lord, the
Or maybe this thing is a little bit different here, huh? Anyways, huh? Will issue notice, let the respondents respond and see.
my lord, till returnable debt, my lord. Otherwise, my lord, this will be in practice. If the further notification is issued from the, my lord, election commission, my lord. So, my lord, at least These have to be stayed till the.
Till the
order.
next date of listing. We'll wait so that you can reply to that also, isn't it? Yes, heard Mr. So-and-so,
Shimo.
learned counsel for the petitioner who has filed the instant writ petition under section 226 of the Constitution of India. For issuance of the appropriate writ or order to the respondents with regards to the notification / order issued against him dated 22/7/2024. Wherein his membership, GPN of 2/6/3, okay? Tido 3/Roman 3, okay, is disqualified from his membership in the Gram Panchayat, and where the post of GPM of 2/6/3 Tigdo Gram Panchayat is declared vacant till further notification from the State Election Commission. Okay, full stop. Then the learned counsel submits that the state notification has been issued against him due to some private interest and enmity with the respondent number 4. And the concerned authorities were misinformed regarding his party, regarding his alleged anti-party activities. Notice be issued to the respondents, Ms. So-and-so, learned government advocate, accepts notice on behalf of the
1,
state
2, and 3.
respondents, number 1 and 3, 1, 2, and 3, is it? Notice be issued to the other remaining respondents through registered post with AD within 3 days, returnable by 3 weeks. Less after 3 weeks. Stop. The learned counsel for the petitioner further states that the impugned order dated, the operation of the impugned order dated 22/7/2024 may be stayed, since irreparable loss would be caused to him if there is any further notification from the State Election Commission on the basis of the said impugned notification, or notification / order dated 22/7/2024. In view of the above, this court find it fit to stay the impugned order 22/7/2024 till the next returnable date. Yes.
Item number 5.
Yes.
My lord, this is my lord, subject matters relates to Mithun, my lord. It is-
Mithun.
Yes,
How many Mithuns?
Mithun, my lord, 3 Mithuns, my lord.
What
So
is
what
the involved amount? 3 Mithuns would be costing how much?
It
1 Mithun is how much? The price out here?
My lord, it would be, my lord, as of now, my lord, the number might have increased, but as per our claim, my lord, it's about 3 lakhs amount. So what happened, my lord?
But before we hear, who's appearing for the
My
response?
lord, they are not appearing, and despite of having received the service of notice, and that's why this has been directed to be proceeded ex parte, my lord.
Wait, let's see. Where, by which court's order dated?
My lord, 31
Okay,
January
30
2020.
2024, yes.
Yes.
The matter will be heard in the absence of the respondents. So what
Well,
happened to the
that's-
three Mithuns?
The matter, my lord, here relates to, my lord, the very simple matter issue is there. My lord, what happened? The three Mithun, which belong to the petitioner, that we have the justified, we have shown in the record that the practical is belongs to the appellant. How, where, right from the beginning of the prayer, from where he purchased, and this we have shown it. Now, this Mithun, my lord, the first female Mithun that was purchased from the Nahalagan and taken to the Kimin for taming, to be tamed there in the conducive atmosphere at Kimin, my lord, under the relatives of the petitioner, my lord. Now, what happened? In the meantime, my lord, the Mithun, female Mithun, given birth,
Calves,
Two
not
calves.
children. Okay,
Two calves.
calves.
and after that, what happened? One of the member of the Mithun club, my lord. There's a Mithun club under in the Kimin, my lord, Mithun Farmer Club. The one of the member had started claiming fraudulently, that marking the fraudulent mark in the air of the one of the Mithun, the claiming that belongs to him, like the kind of
Okay,
fraudulent.
because the male Mithun was given to
Yes,
them.
yes.
Okay.
Now, thereafter, that has been settled. Now they said, no, I'm not the actual owner. And now I'm the only entrusted to take care that
That male
Mithun.
Mithun.
Yes.
Yes.
Now, this was almost settled. Thereafter, all of a sudden, again, one of the member, that is action committee of the Mithun Farmer Club, that is respond number 1,
Yes.
again started claiming, and that too in absence of the appellant here. Appellant is the
Okay.
actual owner. Now, despite of that, he has not been given any notice, but
Okay, you're the owner of the male Mithun.
yes,
Okay.
female, my lord, all mother Mithun and
Okay, the
two
calves.
calves, yes,
That's
three
right.
Mithun.
Okay, okay.
belongs to the appellant. And this, the respond number 1 to 17, my lord. They are the
Club
member
members.
of one club, my lord. That is Mithun, Mithun Farmer Club, Kimin, my lord. Respond 1 to 17. Now, in order to, they have conducted in connivance with each other. They have conducted a mail among themselves. One of them claiming to be the owner, and the rest they have to be a judge. Consequently, behind the back of the petitioner, it has been illegally declared in favor of the respond number 1, who is also one of the member of the club, my lord, in absence of
So you're
petitioner.
saying interested party?
Yes, interested party. They all are interested party. They would not have been. Now, even in the impugned order, it is even clear that
Let's see the impugned order.
impugned order, page 53, my lord. My lord.
So no, but the main dispute is over the calves that were born.
Yeah,
Two calves.
all 3, my lord, 3. The
Three
first
calves were
female,
born. Okay, the female and the three
and
calves.
yes, the last two calves.
Okay.
All together 3.
They want that back. The
Yes.
club owners want those. Okay.
But before coming to page 53, my lord, will see at page 52. This mail was mail order, my lord. It was conveyed, my lord. Mail order that is shown so is hereby modified and reproduced below, my lord. Whereas local Kebang was held in between Thai Soccer complainant and President Secretary Mithun Farmer Club Lora Tok Kimin on so and so 28 so and so in connection with Mitun case at Subansri ground, Kimin, my lord. Now, third paragraph is, my lord, whereas it has been reported by the male bodies, case could not be amicably resolved due to claiming of ownership of controversy Mitun from various groups. This is important, my lord. Now, that order itself is that there was a various group. Now, the contradictory, I will see at page 53. This is the final impugn order, which I'm challenging, my lord.
Case settle agreement. This is the order.
This is settlement, man. This is settlement. Case settlement agreement among the club member themselves. They are the
So you're challenging this.
yes, this one.
But this case settlement, now you approach the
Now-
deputy commissioner's, this thing, isn't it?
Yes, my lord. I'll just
52
read out
official,
read out one of the impugn order 53, my lord. My lord, see at page 53, para number 2. Now, how that just start, I'll read from the starting, my lord. An agreement was made in between so and so, Farmer Club Kimin, first party, and Thai Soka Blade. Thai Soka, he's also member, my lord, among themselves. Arunachal Pradesh and second party, so and so, has amicably settled among the member of Mitun Farmer Club and Sri Thai Soka under following condition. Thai Soka himself is the member, man. The Mitun Farmer Club came in hand over 3 noes of Mitun of Sri to Sri Thai, whose description I sent below, my lord. And there is a second paragraph. If any claim arises from Tadar and Tarak, my lord, this is Tadar. Tarak is, my lord, petitioner, my lord, appellant here, and Tadar is the one who was entrusted to look after the Mitun, my lord. They are Kimin, my lord. Sri Thai Soka will fully responsible for said Mitun. My lord, he's responsible. Now, last paragraph 7, my lord, see that the Mitun Farmer Club has not fully satisfied the statement given by Thai Soka against claim of Mitun, but due to his force and no other claimant, the Mitun Farmer Club hand over the Mitun to Sri Thai Soka. My lord, this is the saying that there is no other claimant. It is, my lord, vague, my lord. At page, it's contradicted to page 52, paragraphs. Third,
One thing, these sort of matters.
my lord,
Now, do you have a mediation center or local
yes, my lord, I'm coming to that point. Yes, I'm coming to that point. Now, against this order, impugn order, my lord, I've challenged, there was
Yes.
the provision, my lord, under,
So you went to the deputy commissioner's court?
yes,
Said,
now, there was some, that is why, my lord,
Yes.
I approached the deputy commissioner
Huh.
under the act, Assam Frontier,
Yes, yes,
there's an act, there's a
yes.
provision for appealing the,
Yes.
against the decision of village authority before the deputy commissioner. Now, deputy commissioner, what they have done is, my lord, prior to that, this order was challenged, my lord, before this honorable court in WPC 105, my lord, is
Okay.
page 62.
And what happened?
Now, that order, my lord, it was observed that since you have an alternative remedy, appeal provision under the act,
Yes.
you first resolve, you just approach, resolve that provision, and
The deputy commissioner.
yes,
Yeah.
the writ petition would not lie. Accordingly, the petitioner was, appellant was directed to approach the deputy commissioner by way of appeal.
Yes.
Now, appeal was filed, my lord, you see. Appeal was filed at page 767. my lord.
To the deputy commissioner.
Yes, page
Yes.
67, my lord.
Then what was the decision?
Now, page 67, my lord, see. Page 67, my lord. The page 67 and
Then decision of the deputy commissioner?
no, page 91, my lord.
91.
Page 91. My lord, although this is in case of appeal against village authority, the appeal under force 46 will like at page 91. although under this provision for appeal, there's no statutory limitation, man. There's no limitation under, in case of
No
appeal against,
limitation period.
yes,
Okay, yes,
appeal against a village authority.
yes, yes.
Appeal only, the delay only lies, applicable only in case of the appeal from deputy commissioner
To the, yes.
and deputy commissioner to the high court and from assistant commissioner to deputy commissioner. That is
Mm.
only where
Yeah,
section
okay.
52
Ah.
says that it should be filed within 30 days.
Yes.
But although there's no such
Okay.
limitation,
Mhm.
the condemnation delay was also filed in pursuant to the direction of this honorable high court, my lord. But this, how this has been, my lord, this has been dismissed. Page 91 appeal is against under section 46, my lord.
Hmm.
Now, the impugn order is at page 131, 131.
Yes.
131.
Hmm.
My lord, see the beginning, an appeal under section, my lord, this has been dismissed by misquoting the provision, misinterpreting.
Hmm.
Now, appeal has not been filed under 47 of the FR. It is admitted on the record, my lord, itself, my lord.
Okay, yes. It's
Misquoting this
46,
provision.
but it is here, it's 47.
Yeah.
Now, what is the difference between 46 and 47?
Yes.
That you.
My lord,
Ah.
46,
Ah.
46, section 46 talks about the appeal against the decision of place authority.
Okay, give me the Assam of
Yes.
Frontier Administration of Justice.
Volume 1. Volume 1.
But in the meantime, don't you have a system of approaching maybe the Lok Adalat or mediation center for these matters, which it
My lord-
appears could be settled in some
Yes,
way?
my lord, subsequently what happened,
Ah,
the
you
new
went?
acts come into force, my lord.
Ah.
New enactment has been passed.
Ah.
Thereby, my lord, it would not, my lord, even deputy commission doesn't have a power after
Okay.
enactment new act. That is
Yes.
why, my lord, ultimately this has to be remanded back to the, it has to be before the judicial magistrate first class, my lord. As an
Civil,
appeal, my-
civil
under the
judge,
new act.
civil
my lord.
judge.
Yeah, under new act. Now, entire fact has to be adjudicated by the JMFC, my lord.
Yes.
My lord, 46, my lord, see.
It's a criminal matter or civil? It will be most probably the civil judge, junior civil judge or something.
Yes, yes,
Yeah,
yes.
junior civil judge,
Yes.
isn't it?
Junior,
Yes.
junior civil, since as per pecuniary jurisdiction, my lord.
Yes.
My lord, page
Anyway,
66,
40,
page 46.
46.
Yes, relevant, it starts from page 53. If it's incorrect, madam, if the
Let's see.
page number is correct.
Yes,
53.
yes.
Yes,
Okay.
now relevant section is page 66, madam.
Hmm.
Madam,
Yes, yes.
any person aggrieved by decision of village authority may appeal to the assistant commissioner in the suit exceeding,
Not exceeding.
not
500.
exceeding 5 days, yes, my lord. And to the deputy commissioner in suit exceeding that value, my lord.
So you went to
Since
the
it is
deputy.
exceeding 500, that
Ah.
before it comes deputy commissioner. Now difference is, my lord, whereas section 47, it talk about
It's
appeal like to
appeal.
deputy
Ah.
commissioner from decision original appellate of an assistant commissioner. Now, this has been misconstrued, my lord,
Mhm.
as if the decision
So
instead of,
you went directly to the deputy commissioner
Yes.
instead of from assistant. Yes, I got
Yes.
your point, huh?
now in view of this provision, my lord, there's misconstruction
Yes,
of this impugn order is, does not sustain, it is liable to be set aside, my lord. Does not stand, my lord, in the eye of the law. Now, in the meantime, what happened, my lord? New act come into force, my lord.
Anyway, so the condonation was not allowed or allowed, not allowed.
My lord.
The condonation of delay was not.
Condonation was rejected and the
Okay,
appeal
not
was
allowed
dismissed, my lord.
because,
That
yes.
is why, against which this
Yes, yes.
appeal has been
Because the
filed.
wrong section was cited.
Yes.
Ah, yes.
Again, this, my lord, section 48, the appeal lies, my lord. That's why this provision was the appeal filed, and there's a
I got your point.
interim
Ah.
order of status quo, my lord, in respect of the subject matter, my lord. Now, During the pendency of this appeal, my lord, the government of Arunachal Pradesh they have enacted the new act, Arunachal Pradesh Civil Court Act, my lord, 2021, my lord. The
2021.
yes, my lord.
Wherein this matter should be placed before the civil judge. Is
Yes,
it
my lord.
civil-
Initially,
Uh,
as part of first principal act, initially, my 2021 act, my lord, that any decision taken against the decision of the village authority, it has to be before the district judge, my lord. But subsequently, that part has been again amended and amended in the the act was first enacted on notified on 12 April 2021. This is correct.
Hmm. 2021.
Yes, this new act came into force, my lord. Now,
So jurisdiction of pecuniary
lord,
jurisdiction, maybe you're trying to
the
show me that.
appeal provision is section 15
15.
and probably last provision, my lord.
Hmm.
This has to be before the district judge, my lord. Now, subsequently, my lord, by this act, my lord, at page at section 27, my lord, by this act, the existing provision of the AFA 1945 Assam Frontier, that's regulation 1945. This has been certain provision has been deleted. As section 27, my lord, see last page, my lord. Serial number 12, my lord. Section 46, 47, 48, 49, 50, this all deleted, my lord.
Yes.
This all deleted, my lord. The no more. Now the deputy commission doesn't have any power now. And
Now this
Now-
order, wait, my confusion, just try and clear this
Madam, thereafter, my
confusion.
lord,
Just try and clear this confusion. So you're saying in the instant case, you want the matter to be referred back to which court?
junior division, my lord. Junior civil judge, junior division, my lord. My lord,
But
see,
this
my
order
lord, this
was
subsequent
passed.
amendment, my lord,
Uh,
is clarified.
Okay, let's
Subsequent
see.
amendment. It was amended, my lord, 4th November 2022, my lord.
Hmm.
Is serial number 3, madam. Amendment subsection 3 of section 15, madam. First page,
Yes.
then close 3, madam. Next page, madam. After the fourth provision to subsection 3 of section 15, the following subsection shall be inserted, madam. Appeal, if agreed by the parties, shall lie before the interblazed customary court or apex court by whatever name called, which shall settle, so, madam. Next, so next para, madam. Provided an appeal against the order of interblazed territorial court or apex customary court shall lie before the court of civil judge junior division, madam. The court of civil judge senior division, the court of additional district judge or court of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. Now here, now in case where there is a, in some other places, madam, there's no civil judge, senior division or civil. In that case, the district judge which covers that, they will take the appeal, madam. And pecuniary jurisdiction here, madam, since we have under this same jurisdiction, we have a civil judge junior division, and a pecuniary jurisdiction since present case is 3 lakhs, madam.
3 lakhs. So
Under-
Mithun is
yes,
around 3
under-
lakhs.
Yes, under 10 lakhs, my lord, the junior division, civil judge junior division is taking care of this subject matter, my lord. So this one, that's why, my lord, ultimately this matter has to be back to the,
Anyways, so in the instant case, we will set aside the order passed by the deputy commissioner since the order was passed under the wrong section of law, okay? It is not an appeal, but they have directly approached the deputy commissioner's court. So it should be under 46. So under 46, there is no limitation period.
yes, yes.
Therefore, the order passed, not condoning, saying that there is a delay of 200 something
Yes,
days.
yes.
This is wrong. So we'll set this aside and we'll refer the matter back to the senior civil judge, which
Junior-
place?
junior
Junior,
Junior-
civil judge,
junior
junior
division.
division, which
UPM,
district?
Papumpara.
UPM.
Yes, ma'am.
Okay, we'll dispose of accordingly.
My lord.
We'll pass the order later.
And
Or
my
should
lord,
I-
there's interim order, there's
Wait, I think
maintaining
I'll
of,
pass the order now so that there's no miss this thing. I heard Mr. So-and-so. Learned counsel for the appellant who has filed the instant first appeal order, FAO, okay, against the order passed by the deputy commissioner dated
29,
29th,
2019.
11/2019. Stop. It is seen that this court in its order dated, where is it? Dated, just put it dash. When is it that ex parte can be heard ex parte by this court?
ex parte, my lord, order dated, my lord, 31 January 2024, ma'am.
Okay, in its order dated 31/1/2024, had observed that since notices upon respondents number 1 to 17 are deemed served and none appeared for the respondents, the matter will be heard in the absence of the respondents. Comma, okay, comma, this matter has proceeded in the absence of the respondents. Stop. The learned counsel for the appellant submits that the impugned order of the deputy commissioner dated so and so is liable to be set aside since the appeal, since the case, okay. Wait, let me see your petition before the deputy commissioner.
Petitioner, my lord, 91, ma'am, page 91.
Okay. Now, this mail order, you're saying MEL, okay, mail order. It is an order of some village
Eh,
court or what?
It is exactly not a village authority also, my lord, but they are purported to be, they are past purported to be a village authority, my lord. They are only the member of club member of Mithun, man. And since some of the Gangra was there, my lord, that it was treated as purported to be a village authority. That's why,
Okay, they are the village because appeal will go to the deputy commissioner
yes, ma'am.
if it is passed by some village court, isn't it?
Yes, yes.
So this may, okay, again, what is the last sentence? Okay, since the appeal, okay. Against the say, against the impugned MEL order, MEL, okay, order number KMN/JUD-07/2018, dated 02/11/2017, 22/11/2017, 24/11/2017, 11/06/2018, and the final settlement order dated 18/06/2018 was made under section 46 of the Assam Frontier and Administrative Justice Regulation, 1945. However, the Deputy Commissioner in the impugned order dated 29/11/2019 had mentioned that the application of the petitioner/appellant was made under Order 47 of the, again, Assam Frontier Administration of Justice, within brackets, okay, regulation, 1945. And had dismissed the application on the grounds that the application/appeal was barred by Section 5 and Section 14 within brackets 2 of the Limitation Act. By refusing to condone a delay of 252 days in filing the appeal. Let's stop. The learned counsel submits that the appellant had approached the Deputy Commissioner not under Section 47 of the Assam Frontier so-and-so Act, but under Section 46 of the Assam Frontier so-and-so Act. Copy paste. In view of the above, under Section 46 of the Assam Frontier so-and-so Act, there is no limitation period prescribed. For the above reason, the Deputy Commissioner had erred in presuming that the appeal was made under Section 47 of the Assam Frontier Administration of Justice Regulations Act 1945, and prayed for setting aside of the instant order and for remanding the matter for fresh education, for fresh adjudication before the court of the civil judge within brackets junior division from what? UPIA.
UPIA.
UPIA. Good stuff. Brief facts of the case is that the appellant was originally the owner of 3 mithuns. Okay. And he had lent his male mithun to the respondent number
1.
respondent number 1 for safekeeping. Is it he did not give for safekeeping?
It is still the mithun is in his possession. Respondent number 1.
Yes, for his safekeeping. For his safekeeping of as a gift he had given to
madam.
him.
The
Okay, had kept the mithun in the custody.
yes, in
the
view of the
custody of
impugn order, madam. Since there's the impugn order.
No. Originally, in the beginning.
Originally, my lord,
Right in the beginning, he gave it to them as a gift or just in the custody. He had
My lord,
kept the mithun in the custody of the respondent number 1.
my lord,
Is it-
my lord,
Huh.
respondent number, my lord, he has given handed over his mithun to his relatives, my lord.
Okay.
Relatives
they made a-
Tadar Takyang, my lord.
Okay, respondent number, is
My
he
lord,
made a
he is
respondent?
not a respondent number.
Okay, to his relative,
Tadar Takyang.
the other Thakia Act, which place?
Takyang. At Kimin, my lord.
at Kiming.
Takyang. Tader Takyang, Takiang.
At Kiming, okay. Meanwhile, the two female Mithuns gave birth to
Calves,
how many? Two.
two calves.
No, one of the female
One
Mithuns.
first is
One
one,
of the female Mithuns belonging to the appellant gave birth to two calves. Is it?
yes.
Thereafter, the Mithun Farmer Club of Kimin claimed ownership of the two of
three
the
calves,
two
all three
calves
calves.
and the female Mithun who had given birth to the calves. Hmm. The members of the club conducted several meetings and hearings regarding the ownership of the female Mithun and its two calves. And finally came to a decision by passing a case settlement agreement, okay, dated, what's the date?
Dated 18/6/2018, man. It's page 53, man.
Okay. page 53.
18/18/06/2018.
Yes, 18/6/2018. Aggrieved by the said decision, the appellant had approached the Deputy Commissioner under Section 46 of the Assam Frontier Administrative so-and-so, okay, whereby the Deputy Commissioner passed the impugned order. Having heard the submission made by the learned counsel for the appellant, the Assam Frontier Regulation so-and-so, Section 46 and Section 47 have been duly perused. It is seen that under Section 46, the order, the matter can be placed before the Assistant Commissioner if the suits do not exceed rupees 500 in value, and to the Deputy Commissioner if the suit exceeds rupees 500. It is mentioned that the cost of the disputed methods is above rupees 500, and therefore the Deputy Commissioner wait. Now, if you look at 47,
47 is,
an appeal.
yes, from decision of original or appellate of the Assistant Commissioner. This is EAC, madam, Extra Assistant Commissioner. This is subordinate to the Deputy Commissioner. In that case,
So then if this is an appeal, so now, no, you have approached,
under 46, against the decision of the
okay,
place authority.
it's an appeal so-and-so against the decision of the Assistant Commissioner. However, since the value of the methane is above rupees 500, the instant appellants had approached the Deputy Commissioner to exercise its original jurisdiction under Section 46 of the Assam Frontier so-and-so, okay. In view of the above, this court, on perusal of the order of the Deputy Commissioner, finds that the Deputy Commissioner had erred in noting that the instant appeal was under section 47 of the Assam Sovereignty. In view of the above, this court find it fit to set aside the order of the Deputy Commissioner dated so and so. In view of the Arunachal Pradesh Civil Codes Act 2021 and the amendment of the Act in 2022, this court also finds that in the matter, it would be appropriate to remand back the matter for fresh adjudication before the Court of Civil Judge, within brackets, Junior Division, then UPIA. Accordingly, FAO 04/2019 stands allowed and disposed of. Yes. Here,
We'll approach the concerned my lord court
yes, yeah,
within 30
Oh.
days.
okay, wait, the concerned parties is to approach the so-and-so within 30 days. From the date of the certified copy of this order. Yes.
And although my lord, the condonation part is, delay part is not there, my lord may observe, my lord, if in case my lord may be condoned, my lord, may not be within 30 days, my lord.
You're thinking too much. You will do it within 30 days, it will be solved. Okay. Yes.
Deeply or less.
Yes.
Yes, possible for time being, my senior, P Vijay is lagging court number, two. Lord.
Okay, time being matter. Yes, 9. What is the matter about?
Your Lordship, I'm appearing behalf of respondent number 5. So, Lordship, I was before the filing counter affidavit on this 7 July. So accordingly, I filed it on 19 July.
What did you file on 19?
Counter affidavit in opposition.
Yes, already filed.
Yes.
Okay. So you received a copy of the counter affidavit?
Yes.
Petitioner,
And also I served extra copy also.
you received. So you want to file reply or no? What? What do you have to submit? Lovely.
Your Lordship, I think the respondent 5 has entered appearance only today.
Has what?
In the last order, we were supposed to publish a notification. I mean, in the
See, on
newspaper-
19/7/2024, affidavit in opposition has been filed. Okay, so did you receive a copy of the affidavit in opposition? He says he's given it to you. So we want to know whether you're going to file a reply to the affidavit in opposition.
Your Lordship, we have received one from respondent number 4, but not from respondent 5.
I
You
have
see?
served.
Okay, now you serve another copy then.
Okay,
Uh,
okay.
Miss
Si, monsieur.
See, say name loud, give it in this in writing, okay? Miss so-and-so, learned counsel for the petitioner is present along with Mr.
Tisiga,
T. Siga, counsel for respondent number
5.
5 and Mr. So-and-so, learned government advocate. Is it? For the state respondents. The learned counsel for, Miss so-and-so, learned counsel for the petitioner submits that though the office note indicates that counter affidavit was filed by respondent number 5 on 19/07/2024, they have not received the copy of the counter affidavit. In view of the above, learned counsel for the respondent number 5 to duly furnish copies of the counter affidavit to the petitioner.
I will start with
Yeah. Thereafter, list the matter on list the matter after 2 weeks on a date fixed by the registry.
Your Lordship, it may be fixed for hearing.
Let's see if they want to file their reply or not also.
Okay.
Isn't it? List it first there, then let's see. Whether you, both of you will say that we're not going to file and that pleadings are complete, then we'll list it for hearing. Admission hearing after that, yeah. Finished, 2 weeks.
Advised your lordship.
Madam, just one small matter addition in the at number 5, madam.
Hmm.
Since there's an interim order, madam, not to dispose of the method in question, madam. Madam, till filing of, madam, this, the order may be remain, madam. Will, the next extension will see in the trial court, madam. That interim order, madam.
Dated,
There's interim order in this case,
dated,
madam.
dated.
Dated, madam. First,
Okay, meanwhile, the interim,
2nd
this
January
will be for the
2020.
other- Okay, meanwhile, the interim order passed by this court not to dispose of the Mithuns is to remain till the
Filing,
till the filing of the matter before the civil judge, within brackets, junior. Yes.
May I, your lordship,
Okay, what?
may the interim order be extended in item number 9?
Okay, after thinking, you're thinking it should, okay. Now item number 9, interim order passed earlier, shall remain till the next returnable date. Yes.
My pleasure. My lord, this is regarding pending of admitted outstanding bill amount. So on 26/6/2024, this court had passed, given last opportunity to the state respondent to file an affidavit opposition by 26th of July, but they have not yet filed, so this
You have
Better
not
maybe
filed, yes.
Yes, your lordship, I regret.
it may be presumed that they have no.
What is the matter about?
Matter is regarding pending of bills, admitted pending bills.
How much?
You're
supposed to receive how much money?
Yes, is my prayer portion. Rupees 1,57,999 rupees.
It's admitted, where do you admit?
There are several communication between the authorities, whereby they have acknowledged there is pending bill, they demand for pound also. My lord, let me take my lord to page annexure. Annexure 3, page 60. This is a confidential letter communication between two chief engineer Eastern Zone A by the chief engineer vigilance and training.
So
This
what
is-
did they say?
This is 15 February
Oh.
2022. This is first letter where have they stated that outstanding claim in respect of Kipakani contractor against execution of various works such and such. As a copy of closure of the SIC vigilance inquiry such as is being received from the Deputy Secretary Vigilance Government of Arunachal Pradesh such and such. In connection with outstanding bill claimed by Sri Kipakani contractor is forwarded to you, your group office, including inquiry report for information. In this is regarding inquiry reports. Now, next page. This is not. Now, page 63. The letter to the executive engineer Sangram division, the concerned division where I bill was prepared. Enclosed file in this regard, you are asked to examine the pending liability respect of Kipakani contractor or submit PAN proposal in prescribed format along with detailed statement of pending liability showing work order number such and such. On the basis of this,
the executive engineer have sent the 64. Name of the project scheme, annual repair and maintenance of assets created under Sangram Division 2008, 9 and 2009 improvement road from Nyopen to Sango 0.00 kilometer to 15 kilometer under SPA during 2008. Name of the circle Yachuli, such and such decision format. Then they have certain queries which was replied on page 65. Then 66. The executive engineer has written a letter to the SE. That is in inviting reference the above cited subject and letter refer enclosed. Please find here with pending liabilities claim in proper format annexure such and such along with copy of work order in duplicate against work annual repair maintenance of asset created under Sangram Division PW during the financial year 2008-9 and 2009-10. Improvement of road from Nyopin to Sango such and such kilometer SPA during 2008 in respect of Shirif Kipa Kane, who executed the assigned work as per work order issue amounting to rupees 1 crore 12 lakhs such and such. Only being a pending liability. Further, it is to inform your good office that work was assumed to be awarded on need basis and very much attached to the general public interest. However, till date, no payment was made against the aforementioned work, even after successful completion execution due to non-availability vis-a-vis sanction of the fund from the government of Arunachal Pradesh. This is a letter from the executive engineer of the division.
So this letter shows that you admitted to the amount, isn't it?
Yes, Your Lordship. But so
So
far
when
we have
can
not
you pay?
even received the instructions from the department itself, Your Lordship.
Obviously, what will they tell you? Isn't it? What instructions do you need now? You will be taking instructions from the department, will be from the PWD department, isn't it?
Yes, Your Lordship.
And the executive engineer has stated that the pending bills are there. And they have paid for the requisition of additional fund to clear the bills. So it's more or less admitted.
Same person will give instruction, the executive engineer.
No, it's the same, isn't it?
Then I'll leave it to Your
So
Lordship.
we'll dispose of the instant this thing, then we'll give you a time frame. Within that, you make an attempt.
Yes.
Keep waiting. If they don't, then again contempt will be there. Then keep going till the payment is made, isn't it?
Oh.
And that's how it's done. Anyway. You heard Mr.
G. Tarak.
G. Tarak, learned counsel for the petitioner, along with Mr. So-and-so, learned government advocate for the state respondents. It is saying that the state respondents have not filed their counter affidavit till date. And this court, in its order dated 26/06/2024, had submitted that, had noted that then within inverted commas, okay, since notice in this case was issued on 02/08/2023 and considering the claim of the petitioner pending before the respondent authorities for the period from 2008-2009 and 2009-2010, no further time shall be granted to the respondents to file their affidavits beyond 26/07/2024. And then again, comma after that, this court find it appropriate to hear the matter since the councils, since the state respondents have not filed their counter affidavit till date. Mr. So-and-so learned counsel for the petitioner submits that the instant writ petition filed under 226 of the Constitution is for the payment of the pending bills to the petitioner after the completion of works wherein the petitioner was awarded several number of works, work orders, okay, by the executive engineer, Sangram Division, Public Work Department, and after the completion of his work, he had submitted his bill against the works completed, amounting to rupees 1,12,05,799 only. Full stop. Thereafter, several communications was made between the petitioner and the respondent authorities for the payment of the bill. Full stop. Being dissatisfied with their responses, the petitioner had lodged a complaint before the SIC within brackets VIG, okay, whereby requesting to unearth the reason as to why the outstanding pending bills are not released. Full stop. The SIC within brackets VIG, that is vigilance, okay, submitted an inquiry report on 28th January 2022 in favor of the petitioner, affirming the claim being genuine. And after receiving the report of the chief engineer within brackets vigilance and training, close bracket, PWD, Government of Arunachal, communicated the same to the chief engineer within brackets, capital CZ-A, PWD, MOB 2, Roman 2, Itanagar for necessary action. It's a little detailed, let me see. Thereafter, after several communications, yes, where's the last order that you read? Yes, the executive engineer. Yes. Yes, Sangram Division, PWD AP, addressed a letter to the superintendent engineer, Yachuli Civil Circle, PWD, Lower Subanshiri District, AP, for the requisition of additional fund / LOC to clear the outstanding liabilities in respect of the appellant, of the petitioner. Full stop. The said letter clearly reflects that the petitioner is entitled to be paid the sum of rupees, again, 1,12,05,799. For his works for improvement of road from Nyiping to Sango 0.000-1500 kilometers under SPA during 2008. During 2008, full stop. Okay. This court, having perused the nature of the communications made by the state respondents, find that it is an admitted fact that the state respondents are liable to pay the respondents the sum of copy paste, okay? Which are his pending bills. In view of the above, the instant writ petition is disposed of with an order that the state respondents are to take steps for releasing the pending bills of the petitioner amounting to so and so within a period of
6 months, Your Lordship.
That is true. 3 months.
We'll make it 3 months, let's see. Okay, within a period,
With interest.
within a period of 3 months.
6 months, Your Lordship, if I may, please.
Since 2008, pending for last.
Yes.
But again, we have to see, let's make it 4 months. Okay, we will give you a grace period within a period of 4 months from the date of receiving the certified copy of the this order. Failure to pay the said amount. Was there in your petition? Where?
Yes.
Where?
Yes.
Interest, where?
Like where is the name of
We'll make it 6, but let me see if we have prayed for that simply. Okay. On failure to pay the said amount within the stipulated time period, the state, there will be an interest imposed at the rate of 6% per annum. As paid and submitted by the learned counsel for the petitioner. Yes, accordingly, WPC so and so, okay, stands disposed of as above.
Oblige.
Yes. What is the stage?
Rent compensation
Oh,
from the,
pleadings complete?
yes, my lord. Respondent number 3 has to file, or respondent number 4 has to file. If he is not filing, my lord, we can,
Who is representing respondent number 4?
CGC.
Yes, learned CGC.
Of respondent, other respondent number 1, 2, 3 in government.
Okay. Then we'll say pleadings complete list for the admission hearing.
Then only the issue is regarding the first position. Right?
Mhm.
The for first position, there is a state government notifications for the period 2008, from the period 2008. From 2008, the rate is fixed. by
What is
state
the matter about? Wait, let's see.
And the, regarding the compensation and the proper acquisition of the that compensation is also paid. But they are claiming for the first position. For first position, it has to be worked out by the district administration as well. But the rate has to be calculated.
Okay, so you're not contesting his claim, is it?
But we are contesting this because the rates are not being fixed. Prior
Direction will be issued to the deputy commissioner in that case. Only direction will be issued.
Where's the calculation?
Prayer, my lord.
Yes.
This have been a meetings with the army authorities and the other stakeholders.
Yes. Prayer page 31.
has to be determined by the ultimately
By the deputy commissioner.
If the learned DGSI says that let it come on records, we are denying.
Oh, okay.
Let
So
him come on
wait,
record.
let's see, what
If
is
he's
the
ready to
matter
pay.
about, huh?
Yes.
Then we'll hear the matter in the next stage. What is it about?
My lord,
Wait, let's see your prayer part.
case 31. I have only one prayer.
So you have to evaluate, now this is the land occupied by the army, is it?
We are ready.
And then they've been occupying the land, and then during the year 1980 till 2021, rent has not been paid.
Yes.
Our record, this piece of land is under the Indian Army.
Indian Army.
1980,
Huh.
and 1980 to 2008, the rate was not fixed. And 2008 to 2022, we have there is a rate fixed by the state. How far it is correct or not,
Okay, now have you cited some amount? Nothing, no amount.
No, the calculation has to be done by the deputy commissioner.
Okay. Now, what is your objection to that? If,
My lord,
huh?
As under the LARA Act, there is no provisions for giving rent. It has to be determined between the rent has to be calculated between the owner, landowner, and the user agency.
Okay.
Now,
So you're admitting that rent has to be paid? That is
we
not denied.
if the user agency is ready to pay, we don't have
Who is the
any.
user agency?
It's the
And
army.
you agree that we'll pay the rent?
That's why if they are agreeing, let them come on
Wait.
by way of affidavit.
Our contention is, it has to be ultimately determined by the district administration, whether rent is payable or not. But my admitted thing.
Who is the district administration?
Deputy commissioner.
Deputy commissioner.
No. Who is representing?
I am. We are not. We are not admitting that we are the authority who will say that whether rent should be paid or not.
No, so he's admitting that we'll pay.
That's why let him come on by way of an affidavit.
Yes,
We don't have any.
I think you pray for time for filing of this thing. Okay, counter, no, yeah, if it's a counter affidavit or admitting that you're going to pay the rent.
No, madam.
Huh.
Our submission is,
Huh.
when our submission,
Huh.
the ultimately, madam, the district administration has to calculate the amount, madam, how much is paid.
Then you will look at the amount and then you'll file your counter or what?
Whether there is be a reasonable compensation, that is not unreasonable compensation, that has to be there for madam.
So your submission is that you admit that you have to pay rental compensation between the said period. But you prayed that, that the amount be calculated by a district administration, is it?
Since the additional AG, they're conducting the case, madam.
I
Prepare and enough that once the rate is determined by the state government along with the district administration, that will be the suffice.
Then you'll pay the amount.
Madam.
You're admitting that you'll pay the rent.
So then follow the affidavit of the other respondent.
We have filed our affidavit. We have denied that there is no provisions of filing
Then in that
payment of rent. It is for the if it is the user agency is ready. That's why if he's ready, let him come in the form of an affidavit.
Yeah, make it in the form of writing.
Yes,
So
that we are ready.
They'll consider your nature because then the rental amount, you're saying that there's no rental amount, prescribed amount during a certain period. Okay.
Madam, in that case, madam, the state government, in that case, madam, state government has to clarify the rate fixed by them, madam.
No, my lord, how can we determine a rate for the landowner and the user agency? It is for
But then you
them.
have to have a meeting and
They have
decide.
to have a meeting within themselves that we will accept this lease, this rent. How can the government enter upon a private party and a user agency that we will fix a rate for both of you? It is for them to negotiate. There is no provisions under the LARA Act that we have to determine.
Okay, you fix, or you suggest that a meeting be held, isn't it? Now,
My lord, may please
But
come to page 80, my lord.
since you have admitted that you have to pay the rent, now the amount has to be determined maybe by the state government also looking at the market value, what is the?
First,
My lord,
Government
that is
has
for
to
land
exercise
competition,
some.
that has already been determined and already been paid. Now for the lease,
Huh.
The rent, my lord.
lease rent, it is for the landowner and the user agency to come
So
to a
have you
conclusion. There was no
suggested
agreement
amount?
between them.
My lord,
Have you
s-
demanded
page
a
80, my
certain
lord.
amount?
My lord, may please come to page 80, my lord. This is the,
81.
my lord, exercise undertaken by the deputy commissioner, my lord.
Huh.
Page
Let's
80,
see.
my lord. Yes, my lord. Of the writ petition.
But
So you're not happy with the exercise?
No, my lord. They are
No?
not completing the exercise, my lord.
Okay.
Page 80, my
wait,
lord.
huh. Wait,
Serial number
just a
one,
sec,
my lord.
just a sec, 1 minute.
Yes,
Page
80.
81.
80, page 80. my lord.
80,
Yes,
80.
yes, that is, sir.
Annexure 17.
Yes, my lord.
Huh.
One, serial number one, my lord.
Hmm.
Private land, LGG, my lord. This concerns to me, my lord.
Hmm.
They have, my lord, calculated, my lord, lease period, my lord, 1980 to 2007, my lord, for 28 years, my lord. They have exercised, my lord. 3 rupees has been, my lord, considered for the rate of the rent, my lord.
No, so they've
Per
already
square
done
meter.
their homework.
Yes,
isn't
my
it?
lord.
But this has been, madam, disputed by the matter, as per the submission made by the matter, ACI. Then, madam, in that case, madam, this is not the correct figure, madam, this is not the correct calculation, madam, made by the district administration. Ultimately, madam, the state government has to fix the matter, how much amount is payable, madam, how much, madam, the per square meter is payable to the landowner. Madam, that has to be clearly notified by the state government.
1980 to 2007, they have calculated. From 2000, again,
Then
up
they cannot-
2008 to 2021, again, my lord, they have to calculate that much, my lord.
Order that a meeting be held for you
Yes,
all
my
to
lord.
decide,
Yes, ma'am.
okay, with
To
all the
Deputy
concerned
Commissioner.
parties
Yes, ma'am.
and then discuss. In the meeting, if the deputy commissioner does not have anything to say, he'll say, give his
Yeah.
opinion, since
Deputy-
some rate has been
Madam,
already
it
made.
says On
Huh.
the part of the, on the deputy commissioner,
Huh.
without, madam, sufficing. Because the state government is along with the land management department.
You also be the present, because if they
Yes,
fix a very high rate,
Madam,
they
if-
come to an
present-
agreement, yes.
Along with the state government authorities, madam.
Mhm.
The instrumentalities of the state government has to be, madam, ultimately, madam, decided.
Yes, yes, okay. Yes, I heard, Mr.
BP chair.
Mr. B. Picha, learned counsel for the petitioner, along with, Mr. M. Kato, is it?
For
Learned
respondents,
CGC
1 to 4.
for, respondents number 1, 2, 4, and Mr. N. Ratan, learned counsel, additional AG for respondents number 6.
6, my lord.
6, and Mr.
We come to for
E. Kambuk, learned standing counsel, land management department. Having heard the submissions made by the learned counsels for both the parties, it is seen that the instant writ petition is for payment of rent to the petitioners with regards to the land
Yes,
occupied by the
Indian Army, my lord.
Indian Army.
Yes, ma'am.
Madam, specifically, first position,
Okay, wait.
in respect of first position.
Past,
Okay,
Past position.
in respect of the past, possession,
Yes.
okay, of the land, measuring, okay, the amount. Now, somewhere I find 481, somewhere I find 2 something,
My lord,
202.
we are agreeing to 202.563, my
Okay,
lord.
amounting to an area of 202.563 acres of land. At, okay, now LGG, capital L, capital GG, within brackets, Glenrock, a close bracket, under Bomdil village of Kitpi Circle, comma, PO/PS Tawang, comma, District Tawang, AP. During the period from 1980 to 2021.
Yes, ma'am.
The learned counsel for the petitioner submits that in an estimated amount was made by the deputy commissioner in Annexure 17 of the writ petition. However, the said amount may be discussed and the appropriateness of this amount may be looked into in a meeting of all the stakeholders.
Yes, ma'am.
Okay. The learned counsels for the respondents have not raised objection to having a meeting with regards to the amount to be paid as rental compensation, since it is an admitted fact that the Indian Army had occupied the said portion of land within the period
1980 to
2021. In view of the above submissions, this court find it fit to pass an order for the petitioner
Respondent.
and the respondents. Okay, all the respondents?
Not all the respondents, my lord.
Respondents and all the respondents.
Not all them. No. Respondent number 4
Wait, let's
and
see,
respondent number 6.
For,
Petitioner,
Okay,
respondent number
yes,
4 and
yes, yes.
6.
Respondent 3, 4, my lord. 3 is.
now
Mr.
what about three? Three is the.
Yes, 3,
Defense
4,
acceptable.
3,
Three,
4 and
four.
6.
3, 4 and 6.
Okay. For the respondents number 3, okay, you write the name, the defense estate officer, so and so, okay. Then
4.
4 is the brigadier commander.
Okay.
4, 3, 4, you write their names, okay.
5 will not be required. And this.
What about 5?
5 will be required, Madam, that's because.
Okay, 5 and 6, okay.
5,
Convene.
secretary, line management would not be required. 6 would be enough. Determination has to be done by the deputy commissioner.
Someone on behalf of the
Yes.
department will go, it's okay,
Yeah.
land manage, I mean, it's
Head of the
okay,
department.
okay, 5, 6. Okay, and 5 and 6 should convene a meeting and come to a consensus on the amount of rental compensation to be paid to the petitioners for the occupancy of their landed property by the Indian Army within the period so and so at so and so. Okay,
Within a
accordingly,
period of 2 months, my lord.
an attempt will be made to come to a consensus and settle the matter within a period of 2 months
2 months.
from the date of receiving a certified copy of the said order. Yes, can we dispose of them?
Yes.
Accordingly,
Yes.
the writ petition stands disposed of.
The state government is whether if it is to be paid, Madam, there are so many other cases pending before this honorable court also, Madam. If the
Similar
pa-
cases,
Several cases,
similar.
No, my lord.
no, similar, Madam.
There has been so many acquisition process. And if
Rental
everyone,
compensation.
yes, most of them has been paid the main compensation, land compensation. If everyone starts claiming for the past occupation, it will start a floodgate of litigation again.
Okay, so it's only for
So
this.
only for this,
Ah.
if they are ready,
Small word, Madam, small correction. If favorable, Madam. If favorable, Madam.
Okay, if you fail to come to some consensus, then a fresh this thing will
Madam,
come.
if favorable, Madam,
Ah.
then, Madam, particular, Madam, maybe, Madam, my submission. It's because, Madam, in this, before this honorable court, so many, Madam, the cases
Ah.
are things for the past.
So what's happening to those cases?
No.
Not yet decided. So therefore, Madam, on the one occasion, Madam, this honorable court, more particularly under Justice Tagia, before his transfer to the Contempt, Madam, made an observation before this honorable court. If he started paying the past positions of the land by the to the petitioner.
If
if it is payable,
Okay, if it is payable.
Malad, if one thing, Malad, one aspect is whether the his past positions,
Past possession,
positions
yes.
rent is whether payable or not. That is one question, madam. And the big issue, madam, that has to be. madam.
That has been answered in RL Jain versus DDA, my lord, 2004, 4 SSC,
So
page
therefore,
79.
madam, if
So
payable,
now you agree that we will pay. You're not disputing, isn't it?
madam, but our contention is, madam, whether our, madam, we are ready to pay or not is another thing. Madam, the state government, madam, apprehension is, if we started making payment, madam,
No,
there is a.
no, see, that will be then a very vague way of disposing of, then it'll,
Yes,
arise another this thing. So I was under the impression that you are saying that we are ready to pay, but we are not agreeing on the amount may be discussed again. If we say if payable, then the same writ petition cannot be disposed of. If then you sit together, we say we don't have to
Madam,
pay.
I think only one sentence, madam, if it is payable to the current petitioner. That much.
But isn't the writ petition about that it should be paid?
My lord,
That's the whole question of, then we can
if
dispose.
the user agency is not ready to pay the
Then
rent,
you
my lord,
file
my
a
lord may not
counter
dispose of the
affidavit.
matter, my lord. Otherwise, it will.
Yes,
this,
yes,
Often
exactly.
plus it of litigation, my lord.
If you don't want to
If he's
pay,
saying that Lord,
if
he
you
is
don't
ready
want
to
to
pay, then
pay,
it's
wait,
all.
if
okay,
you
my
don't want to pay, you file a counter affidavit.
Madam,
If you say we will pay, then we will have a meeting, come on the consensus on the amount.
Yes.
It's as
Yes,
simple
yes,
as that.
madam.
No.
If he's,
So decide, have you discussed to pay or not to pay? It's as simple as that. If you feel that maybe we don't have to pay, then that meeting cannot be held, because then there the objections will be raised. Then,
madam,
yes, so I think you pray for time to file a counter.
madam.
Okay, let's dispose it.
Yes.
Okay, okay, long discussion. Anyways, so you're clear about your stand,
Yes.
isn't it? Then heard so and so. Mr. M. Mato, learned CGC has prayed for further time to file their counter affidavit. Yes,
they have already filed.
Fine,
they filed.
madam.
With,
Then-
with the above observation, this
Okay,
writ petition may be disposed of.
So and so,
Madam, simply, madam, then in that case, madam, matter may be fixed for the admission hearing. madam.
okay, since pleadings are complete,
Yes.
okay, list the matter for admission hearing. But be clear on your stand.
Yes.
Whether you're going to pay or not. Payable or not,
That
that's
is
a
the only
different matter.
difficulty, madam, then we can-
So whether it's payable or not has to be decided by this court.
Even
Isn't
if
it?
we pay, madam, this is government, they will again, madam, there will be again counter, madam, contradictions. Then, only because on the admitted part, on the part of the, madam, the user
For
agency. madam.
admission hearing, okay, let's leave it at that.
Madam.
Mm.
Leave them.
Yes.
God bless you.
Yes,
My lord, I posed a moot question yesterday. Why the applicant has not approached the first
yes,
court?
because there are decisions of various.
No, my
courts.
lord.
So you.
That
tell us,
Guwahati High
yes.
Court judgment,
Uh-huh.
2015,
That
that has created confusion.
yes.
In 2015, there was some issue.
Mhm.
Then the law being perverse, laid by the division bench, then Sridhar Rao, that was put into challenge, and this has been stayed
Okay.
by the apex court.
Uh-huh.
So that judgment I'm pressing. Where is that? Have you brought it? No, no. Which judgment? 2015, Malad? 2015. Where is it? I'm passing this, Malad.
Yes, because we have to go by the division bench, isn't it? Different high courts have made different
No,
observations.
no, all,
But
everything,
division
all
bench,
those.
yes. So the question of the operation of the pending order is kept in abeyance till further orders. This is dated 2017. And then,
Correct. And the matter was listed last on 1st March. It's still in session of the Supreme Court. So therefore,
so what do we do?
no,
But
no,
there's a different observation of the 5-judge bench of the Allahabad. High
no,
Court.
that High Court,
No doubt, my lord, this matter has been kept in abeyance for a time being. But there's a observation
the
of the 5 bench.
operation of the division bench judgment of the Guwahati High Court is in stay. So therefore, there is no confusion, even by a stretch of remote imagination, that one cannot come to the High Court for to file an anticipatory bail under 438. This is byproduct of the statute, my lord. And the interim could. So therefore, this was, my lord, no research was done. And I recall, my lord, that Ikram Iwobi Singh case. In Manipur court, High Court, I went with Sir Salman Khurshid. So this particular thing was also, where is that judgment? I have asked you to print out. So, my lord, what had happened in that case, it was referred. My lord, that print copy, my lord will have to adjust with me for a moment. You should have taken a printout. My printer was not good. No, that's why.
You see, because there have been judgments where when they are these two, when they have the dual power, the High Court and the Session Court, then the usual practice that it goes to the Session Courts and then to the High Court.
Then, my lord,
But that was the observation of the
various
DP
high
of this
courts,
court.
various high court,
Various high
including
courts.
this high court.
So actually, it's good that it has gone to the apex court
Yes,
to
it
settle
has been
this
stayed.
matter.
So therefore, my lord,
Hmm.
what was prevalent at that point of time will prevail now also. Because what was the practice and procedure
Okay,
that was prevalent?
but during the 2015.
Yes.
Okay, during 2015, issues were raised by various high courts concerning this. And various high courts, you had different opinions, I think, isn't it? So then we'll have to look at the position before 2015, the judgments and the observations made by the various high courts. So it's open to the court then to decide
ma'am.
or not, isn't it?
No, my lord, basically, my lord, we should be concerned with our own high court judgment. When that particular judgment has been stayed by the apex court, then what happens is other high courts' judgment are not binding on us. We can only, my lord, take a reference of the principle of law that they have discussed.
Okay, anyway, you give your submissions. I have my own idea to be
No, my lord, this has to be clarified first.
Yes.
Then otherwise, I have my judgment 2024 judgment. latest judgment.
Yes. Let's see the 2024 judgments.
Kindly have this 2024 for SSC. Well, sorry, my lord, the print copy I have left. 2024 for SSC.
The judgment which I have placed, my lord, that is a five-judge bench of Allahabad High Court, which has a similar observation as observed by the Honorable Guwahati High Court.
Okay, Guwahati High Court.
Yeah.
This is which year? 2000.
Then in
2000,
that-
my lord,
Now suppose-
20.
My lord, for example now, till yesterday also, today also, I think bail matters are listed. If my lord have to take a contrary view, in that case, all the notice issued in all the previous bail applications, even till yesterday, this has to be recalled.
No, what has been, unless those are
No,
challenged.
that's why, my lord.
Unless those are challenged, leave that, we are
Yes.
doing it as of today.
No, that's why,
Previous is not challenged, what all bail applications? Before previously, lots of bail applications
no,
were
because
directly.
my lord is basically guided
what-
by this 2015 judgment. Because my lord cannot travel with the decision arrived or the law laid down by the various high court. It can have that opinion also, this opinion also, but basically,
It's
my
not
lord,
going to be late, but
Yes.
we can consider,
but my lord have.
it's not binding on this court, obviously.
No,
That
not
we
binding.
know,
So therefore, my
It's
lord,
not binding, that we know.
let me answer in a very
Yes.
simple way.
Ah,
Court do not legislate the law.
ah,
It can interpret
yes.
the law, and then even cannot supplement unless or otherwise you are striking down the law.
Mhm.
And then, my lord, then what happens? The new concept of the legislative jurisprudence is that even latest judgment is the apex court judgment.
Okay, give
that
us those
Supreme
judgments.
Court- But even any law laid down by the courts cannot directly be overruled by the legislature by means of enactment. Only the basis can be strike down.
So give me those judgments.
Well,
here.
these are,
Ha, ha, ha.
now it is coming to the subsequent point, I can provide,
Yes,
Milo.
yes,
There is
yes,
no harm in that.
yes, Yes.
So therefore, Milo,
Hmm.
now for this appreciation, Milo, kindly have 439 once, 438.
Okay, give me the CRPC. You see, because there are
Hold on.
bail provisions, anticipatory bail provisions, where both the courts can be approached. Okay,
There is concurrent jurisdictions.
but
you have-
usually, and there are many judgments regarding
Yeah,
this. So it's good that this has reached the apex court, so that the apex court can settle this once and for all.
Subject to
That's
the
what-
outcome, my lord, still pending.
Which, yes, which is still pending before the court. Different judgments were there, yes.
439 Nikal. Let us do away with this, because there cannot be any misconception
Yes, yes, yes.
or misnomer, thereby curtailing the right provided under Article 21 of the Constitution to the citizens.
We are not curtailing the right. You're
Yes.
saying you have a.
Actually,
alternative,
what will
huh,
happen
huh,
is when the
alternative
constitutional
remedies
courts,
there, huh.
when the constitutional court
Yes,
sits even on the jurisdiction of right from 436 to 439, then what happens? The lower court decisions can always be overlooked. And there, my lord has rightly said yesterday, why one forum is being lost by the
yes,
applicant.
yes.
My lord, to be very fair side, is that at the peril of own risk, the client approaches before this court. Otherwise, legally, constitutionally, there is no bar. I can come. My lord, let us have this.
Yes. Now, 439 parts of the High Court and the Session Court, it's
Yes.
mentioned, huh?
Hmm.
Doesn't say who to approach first, it's
Yeah.
just there, blank, huh?
But
Huh,
the legislature
yes.
has never given that mandate to the High Court, directing the litigant to approach the.
It's not there,
First-
yes, it's
So
not there.
therefore, my lord,
huh.
law cannot be legislated by this court.
But
What
it's-
is there in the
huh.
law, it has to be followed.
In spite of that, there have been many, yes, judgments regarding that. Okay, that is there. So that your submission is, the law is clear, you can do it. huh?
You can do it.
Yes,
So therefore, my lord, even now 438 has to
and
be.
that the judgment of the division bench has been
stayed.
obeyed. That's your submission, yes.
That's it, my lord.
And-
Otherwise, my lord, if we go through the judgment of the five-judge
Yes.
bench of Allahabad High
What
Court,
is their
a
reason?
similar observation, my lord, unless and until there is exceptional circumstances, the one has to recourse to Sessions Court, my lord.
Hmm.
Unless and until that has been exhausted, that remedy has been exhausted.
The
Straight away, filing a anticipatory bail application before the High Court,
Let's see, yes.
apex court
starting
in
from
this
page
letter-
number,
in this-
page number 10, my lord.
The apex court, ruko.
Yes, let him complete first, yes.
Page number 10.
Wait, yes, no, let Mr. Tara complete his submissions first, then we'll hear you. First, then it's crossing her.
This is the difficulty in our court sometimes.
It's okay, it's okay.
Well, because like, see, the word learned
Huh.
is affix or suffix before us. Probity demands
Okay.
that once I complete,
Yes,
then other
so
side
you
will
will
make a
complete,
submission
yes.
instead of interrupting. And then once he has made a submission, then I have a right of rejoinder.
My lord, with all
No, no.
fairness, I don't think there's any
No, no,
dispute
we are not saying.
presently, my lord. It's a very simple issue which can be decided in 2 minutes only.
Complete his submission.
I'm not interfering, man.
No, I'm not
Yes.
saying that. I'm what,
So give me
I
a
have given the
judgment.
examples only. Mara, now see what happens.
Hmm.
The apex court in the same order in our High Court order.
Okay,
No,
great.
I'm giving this. On 1st March 2023, it has said,
Hmm.
the issue raised in this appeal is whether the High Court exercising jurisdiction under section 438 of the Code of Criminal Procedure
Give
1960,
me a.
1973 has discretion. Let us read together, Bella.
Yes, yes.
The issue raised in this appeal is whether
Hmm.
the High Court exercising jurisdiction under section 438 of the Code of Criminal Procedure 1973 has discretion not to entertain such an application on the ground that applicant must first
Yes.
apply to the Court of Session.
Yes.
Now, in
exactly.
view of the previous order 2017, even the Allahabad High Court
Yes.
which my learned PP has referred to,
Oh,
they
this
could
is
not have rendered that judgment.
2023,
Could not-
2023.
Yes, now that has been overcome here. Now
Hmm.
till the Superior Court, it says in our view, a decision on the aforesaid issue would have ramifications. Now it says the apex court is of the considered view that this issue must be resolved.
Yes.
So therefore, everything merges. Doctrine of merger will occur, my lord. So therefore, this court does not, does have a power to take up the anticipatory
So
bail.
the apex court on this issue has not passed any judgment at all.
Yes.
Yes, it is left pending
Hmm.
and the matter has been listed. Yes.
Now therefore,
This is a 2023 matter. Hmm.
now therefore, my lord, thus the learned public prosecutor has relied the 5-bench judgment of the Honorable Allahabad High Court. So similarly, once there is a stay on the same fact, same issue, then what happens? The apex court is in session of the matter. Now, my lord, you got that?
Okay.
Got that judgment?
Which one?
The 2024 for SSA, I have also done some exercises, my lord, after my lord has posed this question.
Yes.
Now, my lord, only the issue was particularly on that. I'll come straight where my lord will see para 32 to 38.9. Legal is, it says evaluation, legal framework.
Yes.
Before discussing, my lord, before that, my lord will just refer to para 31.1 and 30.2 for a moment. Just for a reference, my lord. Then 30.3 says what order? 31 says the aforesaid questions shall be considered together as they are intertwined. Legal framework, now it has been discussed, all those judgments, my lord.
Okay.
Before discussing the points for considerations in the present appeal, the relevant provisions of the CRPC are exposited as under Section 33, my lord. Section 2E CRPC defines High Court to mean the High Court for the state in relation to an state, in relation to the Union Territory. It is defined as that High Court for a state to which the Union Territory jurisdiction has been extended. In a case of any other Union Territory, it means the highest court of criminal appeal for that territory other than the Supreme Court of Section 2J defines local jurisdiction, which I have raised, my lord, yesterday, Section 177. Now we can escape, my lord. That paragraph 36 talks about territorial jurisdictions, my lord. Now, my lord, kindly see how bail are to be granted at paragraph 37, 34, 38, my lord. Now this discussion has taken place. Everything is dealt with. My lord, kindly come to paragraph 38.5. In addition to the aforementioned substantive factors guiding the exercise of judicial discretions, Section 438 CRPC engrafts certain procedural requirements. The High Court or the High Court of Session may grant the procedural requirement. The High Court or the Court of Session may grant an interim order. My lord, see.
Yes.
The apex court has clearly laid down now.
Yes, so go ahead, keep reading.
So therefore, my lord can exercise the power.
Just read a few more lines.
Yes.
You have stopped in
The
between.
High Court or the Court of Session may grant an interim order under Section 438(1) CRPC in case of facts and averments in the application satisfy the factor laid down. However, the proviso to Section 438(1) CRPC provides that if such an interim order is denied, the officer in charge of police station is liberty to arrest the applicant without warrant. Even if the interim order is made in favor of applicant, the High Court or the Court of Session is mandated under Section 438(1) CRPC to cause a notice of not less than 7 days along with a copy of interim order to be
The
served.
rest is discussing the
Yes.
anticipatory bail.
But
So
these are the provisions. Now, my lord, will come High
Ah.
Court or this thing, my lord. Interpretation is from para 78 to 83.
Okay. Just a second. Yes.
Is para 78.
Hmm.
The answer to the point for consideration raised here would emerge from the construction that it is afforded to the expressions High Court or the Court of Session in section 438 CRPC. It was submitted before us that the use of definite article before the High Court and Court of Session must mean that High Court and that Court of Session which exercises territorial jurisdiction over the area where an offense has been committed. Well, a very explicit blood. It is indeed a thrice rule of statutory interpretation that penal statutes are to be considered strictly. When acts are to be made penal and are to be visited with loss or impairment of life, liberty or property, it may well be argued that personal liberty requires clear and exact definition of offense. Furthermore, appropriate care must be taken to adopt an interpretation which makes the textual
So
interpretation.
this describes the anticipatory bail and under what conditions, isn't it?
Yes, the 83, my lord, will come.
83, yes.
These are there, my lord. Para 85 talks about a remedy such as anticipatory bail accrue citizens afflicted in difficult circumstances. Now I am apprehending because a civil case has been given a criminal color by filing an FIR. Now, my lord, come to para 100.
Yes.
101. It says there is no restriction.
Yes, 101, read.
Yes.
Read the paragraph.
Further, on a reading of section 438 CRPC, we do not find that the expression the High Court or the Court of Session is restricted vis-a-vis the local limits or any particular territorial jurisdiction. No, my lord, law does not empower my lord to take up this anticipatory bail.
So this is
That too when-
territorial jurisdiction. isn't
Yes,
it?
kindly come that paragraph 106.2 onwards, my lord, the finding is.
Hmm. So here the orders of the additional sessions judge not granting
Yes,
anticipatory bail was.
my lord will have
set
the
aside.
constitution for the moment. Let us examine article 142, what it says. Please pass over article 142.
Article 142.
Yes. This is a law laid down by the apex court. It becomes a binding, and that binding, my lord, will find in article 142 of the Constitution of India.
So we should stick to all this. Okay, anyways,
Can we see
142.
article 142?
huh.
Law laid down by the apex court. It's a binding on all courts.
So this case does not really dwell into the question whether the matter should first be referred to the sessions court or not. However, the apex court has now for the time being stayed the operation of the division bench. Isn't it?
That is the issue.
Ah.
A simple issue, man.
If the operation of the division bench for the time being
Therefore,
is
my lord,
stayed,
I was clarifying, my lord, the law does not empower my lord to take up this anticipatory bail. Because for 3 months in 2015, we also faced the same problem. After
Okay.
that impugned judgment
Ah,
was rendered
ah.
by His Lordship Sridhar Rao.
ah,
Then all of us were asked to go to the lower court. Then what had happened, my lord? There was a junket. The lower court was filled with the anticipatory bail and the bail. Even below that 438, 439 was to be resorted before the session court.
Sessions court.
Then what happened was there was a junk of bail applications in the learned trial court, and then the regular trial could not be conducted. So therefore, it was the reason why the Guwahati High Court Bar Association stood up. It is the appeal filed by the Guwahati High Court. The court officer of this Honorable Guwahati High Court, we finds that the law is perverse. Therefore, this cannot be a binding precedent to override Article 21 and the intent of the legislature that has prescribed in the section 438 and 439 of the CRPC law. That is the reason why the apex court has also interfered. It was filed in 2015, but the interim order was granted in 2017, my lord. So that is the simple issue, my lord, as simple as my brother public prosecutor has also said. So therefore, the law is very loud and clear that my lord can take up.
Okay, now since, I'll still say since the operation of the DP, okay, division bench concerning the judgment dated 2025.
Correct.
Though I will still
Oh,
make
but
my
not,
observation, though I'll still make my observation.
Yes.
I'll still make my observations, but maybe we'll hear the matter. Okay. Which the matter is still pending before the apex court, for the apex court to decide whether to set aside the judgment or not, but the operation has been stayed for the
Yeah,
time.
my lord will have to
Yes.
follow this judgment then. What is there? That's why I refer to Article 142 of the Constitution.
I'm not
My
saying
lord
yes
is
or
not
no.
getting me, then I'm sorry, my lord.
I am not saying yes or no. You have not even heard my this thing, and you are getting heated up for nothing. Just relax, sit down.
No, my lord,
Take
that's,
it,
I'm
sit down,
placing
sit down.
before my lord and my lord
Yes,
is not
yes.
getting me. Therefore, my lord,
How do you know that I'm not getting you? How do you know that what order I'm going to pass?
I'm not saying that.
Then?
My lord, I'm not saying that
See,
my lord will
you
reject my
don't- you don't
application or
expect
this.
the
I'm not
court-
saying that.
You don't expect the court to say yes, sir, every time to
No,
whatever you are
I don't say
submitting.
that. I have a greatest respect for the
So
institution.
therefore,
Correct, my lord.
while I am voicing my observations, it is for you to listen, okay, and not interrupt every time. Okay. My observation is that since the apex court, okay, for the time being, has stayed the judgment of the
Guwahati High
division
Court.
bench, Guwahati division bench, regarding the anticipatory bail applications, which the court had held that it would be more prudent in such matters to be first placed before the sessions court, isn't it? Isn't that what the judgment says? I think so.
Yes.
Okay, so in view of the above, even though this court feels that it would have been more appropriate if this anticipatory bail application was first filed before the sessions judge, taking into consideration the fact that the applicant would have a two-tier venue, okay, to approach the court if it is set aside by the sessions judge. However, considering the fact that such an observation has also been made by the division bench of the Guwahati High Court, which has been stayed by the apex court. Okay, this court finds it appropriate, okay, to consider the instant anticipatory bail application.
My lord, only
Okay.
if my lord only.
So I will consider
No.
and let's hear. Now give us a
No,
reason.
No, my lord will accept or not.
Huh.
Once the matter is in session of the apex court,
Huh.
in terms of Article 142,
Huh.
my lord may have some restraint to interfere in interpreting the law.
No, but it has stayed. But since it has stayed, since it has
My lord,
been stayed now,
my lord,
I am going.
may I be folded and request? I will try in some other bench.
No. Since it has been stated by the apex court, I am going to go as per the observation of the apex court and hear your anticipatory bail application. Okay, that's it. So let's go ahead. What is the reason for
Because
you?
Milord, I am finding that either I'm not able to communicate with my lord.
No,
or I'm not able to follow my
understood.
lord.
I have understood. And this court is bounded by the decision of the apex court and the observations of the apex court. Okay? Because this
Okay,
court
my lord
is
mean,
bounded.
my lord mean to say that,
Uh,
making a small observation.
Uh-huh.
However, this bail application has been taken up.
Yes, that's
Yeah.
what I'm
And then-
taking up.
then-
So I'm taking up. I'm taking up your bill
No,
application.
because that was the only catching moot point
Uh,
where there was a communication gap between my lord and myself.
Yes, yes, yes.
So now my lord has
So
clarified.
now we will take up your
Yes.
anticipatory bail applications
Correct, my lord.
with the observations, okay, that it has been stayed and still this court has to.
Power and
Yes,
proceed under this. Yes.
I think we are agreeing on the same point, but we are not.
Able to see
communicating.
together. Able to see
Yes,
together.
yes, okay, so go ahead.
Now, my lord, kindly see.
The reason for your
I was-
anticipatory
was-
bail
yes.
application.
My lord, only yesterday this pertinent question has forced me to burn some midnight candle.
But it's
And
good.
thankfully, we
That's
have
good
burnt it also.
exercise. Good exercise. Yeah. That's what you should do. The junior advocates burn candles every now and then. Yes.
And also at the same time, before I start, I regret my public prosecutor also has misunderstood. But I was trying to say, my lord, only, no, just correcting, not correcting only. There's simply, my lord, sometimes what has happened is, I was referring to one small thing. Sometimes what happens in most of the courts, once the counsel is making submission, there is an interruptions. And when other side is also making submission, there is an interruptions.
But only
But
thing
the
is,
procedure, the prudence is, my lord, once if the PP is making submission, then I have to keep quiet. Then if I am making submission, then the PP has to keep quiet, observant, and then rejoinder. Now, my lord,
Anyways, it's time for lunch break. We'll meet again at 2
2.
and we'll consider your anticipatory
Correct.
bail application. Okay. Yes.
Pass over for the matter, item number 6, Lordship. Lordship, J. Lordship, my senior Lordship, J. Lordship. Item number 6, Lordship. Have some personal difficulty and have the dishonorable court premises, Lordship.
Okay, mention
This
is
matter may
made
be-
on behalf of Mr.
Mr. J.
Dejide, learned counsel for the
Petitioner, Lordship.
petitioner for adjournment of the matter since the learned counsel cannot, is absent due to personal problems. Okay, cancel they cannot, is absent. In view of the above list,
After week.
after 1 week. Yes. Yes, let us continue.
yeah. My lord, now, the fact involved in this case is that the petitioner and the complainant, they came to know each other because they were in the same party. One was executive member in the party and another was a Jila Parishad member. My lord. Then they came to a agreement that I will prepare schemes for him and get it sanctioned from the government of India. So in between, nothing had happened. Then this criminal case was set into motion. My lord will kindly come to the FIR, page 14. My lord.
Yes.
It is verse 16/6/2024. My lord. It is to bring your kind notice that one Sri so and so presently residing at Vivek Bihar, Itanagar has cheated, deceived, and dishonestly indulging by receiving a sum of rupees 100 lakhs, 10 lakhs, sorry, 10 lakhs on so and so, 3 lakhs on so and so, a total of rupees 13 lakhs through online transfer with Indian bank, self-check number so and so, enclosed so and so, so and so, owned by Sri so and so, from me in pretext of preparation of central sponsored schemes, which would be incurred a expenditure in miscellaneous constituency in the Ministry, Government of India, New Delhi. At the same time of receiving my above rupees 13 lakhs, he stated before me that a suitable central sponsor, my lord will mark this, suitable central sponsored scheme will be accorded as sanctioned in the month of December 2021, and same will refund this, my lord will mark this, and same will refund this borrow amount within 3 months with a date of receipt, and that is December 2021, after completion to a court of administrative approval and expenditure sanction from the ministry. It is pertinent to mention here that after receiving the above mentioned amount, he has started to avoiding my phone call, WhatsApp message, text message, etc. Despite of so many form of communication made to him in due course, later it was found that his cell phone number becomes switch off. Sometimes in 2023 early part somehow I managed from some source found his number, where I called so many times and found that this number were always working, but unfortunately he did not respond and deliberately avoiding and absconding from last 3 years now. As such, I would like to acknowledge that the act of Sri so-and-so is attracting an ingredient of criminal offense of cheating, deceiving, and dishonestly inducing such a deliberately absconding after committing this crime of cheating. Therefore, yours. My lord, one thing, my lord, will see. First thing, there was a commercial dealing between both of them.
Yes.
And secondly, my lord, there was no intention, my lord. Now, to attract section 420, my lord, and 318 of the BNS, my lord, there must be an intention, my lord. Can you give this criminal manual, old manual? We go for
BNS.
IPC. 420.
IPC,
IPC, my lord.
420. Yes.
420, my lord. It says, my lord, cheating and dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induces the person delivered to deceit to deliver any property. Here, my lord, it is not a property. To any person or make, alter or destroy the whole or any part of valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also liable to be fined. My lord, cheating that I'll read. My lord, kindly, there is one comment here. The judgment I have forgot to bring. There has to be, but a judgment says 2011 7 SSC, page 59. It is in the comment section, it is written, you know, there has to be a dishonest intention from the very beginning, which is sine qua non to hold accused guilty of commission of said offense. Now, my lord, intention is not there. The only sole intention was that both of us come to a conclusion that you give this much of money, I'll prepare schemes and get it sanctioned, and somehow it was not materialized. Now, my lord, in one of my paragraph, I have categorically said, I'll return the money.
You have returned or
No,
you will
I will return the
Okay,
money,
you will
in
return.
one of the paragraph, my lord. Because now after this, my lord, the police is after me. Paragraph 7, my lord, kindly come paragraph 7, and I will come to that statement. Page 5 of my bail application. That it is to state that on 10/7/2024, the applicant got a call from his family member that he is looked out by police in civil dress and directing his family members to tell the applicant to appear before the officer in charge, police station Narlagan, and in connection with the present complaint case. Therefore, the applicant apprehends of his arrest in connection with so and so, so and so. Now, paragraph 8, it is important that the applicant begs to submit that he never made a promise to return the complainant money within a period of 3 months. But here, only 3 months period is the difficulty because that sanction was not there. Date of receipt, be that as it may, the applicant fairly concedes that 13 lakhs only was received from the complainant without any terms and condition. More so, he is still ready to refund the complaint money. I want to return this. Kindly protect me. So that
FIR is filed, registered? Okay, it's been registered.
Registered.
Yes. So you have this fear of being arrested?
Yes.
Yes. Apprehension?
Apprehension is there.
So at this stage, we can grant interim pre-arrest bail, and the
Yes.
main thing can be heard in the next stage, isn't it?
Correct.
Yes, heard Mr. T. Tara, learned counsel for the applicant. Along with Mr. So-and-so, learned, I think, for the state respondent. This is an application filed under section 482 of the BNSS 2023, within brackets, section 438 of the Criminal Procedure Code. Now repealed, close bracket, praying for grant of pre-arrest bail to the accused applicant in connection with Naharlagun PS case number 68/2024 dated 03/07/2024, registered under section 420 IPC.
My lord, I am
The-
required
the-
at court
the-
number 2. I am required at court number 2, my lord. My
Okay,
young-
your junior.
Yes.
The maintainability of the instant application for pre-arrest bail was first heard by this court. This court finds that though it would have been more appropriate if the application was first filed before the Court of Sessions, since it would have been in the for the advantage, or it would have been in the interest, okay, of the applicant, if an opportunity, if he had the option / opportunity to approach this court, even in the instance his application for anticipatory bail was rejected by the Sessions Court. However, in view of the order passed by the Apex Court, in criminal, appeal within brackets criminal numbers 6457/2015, arising out of impugned final judgment and order dated 10/04/2015 in BA number 3024/2014, passed by the Guwahati High Court, wherein the Apex Court had stayed the operation of the impugned order and had kept it in abeyance till further orders. This court find it fit to consider the instant bail application. Then Mr. So-and-so, learned counsel for the applicant, submits that the applicant and the respondent finds that an FIR, so an FIR was filed against the applicant by the informant on 16/06/2024. For an offense under section 420 IPC, wherein the applicant had received a sum of rupees 13 lakhs through online transfer with bank checks. Okay, so I will not write the number. The informant has falsely accused the applicant of cheating, of being cheated, since the applicant has every intention of repaying the said amount of 13 lakhs, so and so. The learned counsel submits that on the registration of the said FIR, he has the apprehension that he would be arrested any day, and that on his arrest, he would suffer, and that he would suffer greatly on his arrest. Greatly for a crime which was not committed to him. The learned counsel further submits that the nature of the transaction between the parties is purely of a civil nature with no criminal intention under section 420 IPC. The learned counsel has thus prayed that he may be allowed anticipatory bail. So, having heard the submissions made by the learned counsel, this court finds it fit to grant interim pre-arrest bail to the applicant with a bail bond of rupees 20,000 and one surety of the like amount, who shall be to the satisfaction of
Arresting authority.
the arresting authority in the event of the arrest of the said applicant till the disposal of the instant anticipatory bail application. Mr. So-and-so, learned PP, accepts notice, issue notice, okay, Mr. So-and-so accepts notice on behalf of the state respondents, requisite copy of the application to be duly furnished to the state respondents. List on,
12th of August
okay.
for production of case diary.
12/8/2024. Meanwhile, the CD, most probably,
CD.
the CD to be called for. Yes.
Obliged, madam.
Yes.
Your Honor, in item number 14, bail file counter affidavit, Your Honor.
Counter affidavit.
Yes, Your Honor. I'm good to petitioner. They have to file reply counter affidavit.
The learned Mr. who is for the respondent?
In CRPC, Your Honor, I am the respondent here.
Okay, Mr. So-and-so, learned counsel for the respondent has prayed for further time to file the counter affidavit. In view of the above, list after
3 weeks.
3
Your Honor.
weeks.
Obliged, Your Honor. And Your Honor, in WPC, item number 15, Your Honor, here, the land department, they have to file counter affidavit. They have to
Again,
file-
counter affidavit,
Yes, Your Honor.
is it?
Your Lordship, we have already filed, Your Lordship. I am for 3 and 4, Your Lordship.
Okay, so government they have filed.
Yes, Your Lordship.
So, your respondent number
I think, I'm the petitioner here, you know.
in the petitioner?
Yes, you know, then, well, in that case, we'll file reason there, you know.
Okay, Mr. So-and-so. Learned counsel appearing on behalf of the petitioners has paid for time to file their counter affidavit. Is it? Yes. Okay, respondents, you have filed your counter affidavit, is it?
My lord, I am appearing for secretary, land management, and my lord will not be filing separate affidavit. Will be relying on the affidavit filed by the.
Okay, while Mr. So-and-so learned, government advocate, isn't, has submitted that they will not be filing a separate counter affidavit, but will be relying on the counter affidavit filed by the
Respondent number 3.
by respondent number 3, is it? Yes. Yes.
Your Lordship, in this matter, there are 9 respondents. However, only 3 respondents have filed their counter affidavit so far.
So who's the counsel for the other 9? 5 to 9, is it? Yes.
Here, lordship, I am appearing for respondent number 1 and 2. Here also in this case, I will be relying on the affidavit filed by the deputy commissioner, my lord, because the.
By the other respondents or respondent number?
Respondent number, my lord, the deputy commissioner is
Respondent
6.
Okay, have they filed the counter?
Yes, respondent number 6 have filed.
Okay, Ms. So-and-so, learned counsel for the petitioner is present along with Mr. So-and-so, learned government advocate, is it, for respondents?
Number 1 and 2, my lord.
1 and 2, and Mr. So-and-so. You are standing counsel?
My lord, for respondent number 1 and 2, my lord, may say that standing counsel for the this
For which department?
land management department.
Okay, land managed department. And
I am for 5 to 9, Your Lordship.
government advocate.
Yes, Your Lordship.
So 5 to 9, you have filed your counter affidavit.
Respect of 5. And
Only respondent number 9, respondent number 6, and respondent number 4.
So how can you be 5 to 9?
no, Your Lordship, in respect of 5 and 9, we have filed.
5 and 9,
9, yes.
okay. While Mr. So-and-so, learned government advocate for respondent number 5 and 9 submits that they have filed their counter affidavit. The learned standing counsel submits that he will not be filing a separate counter affidavit, but will be relying on the counter affidavit filed by respondents number 5 and 9. Okay, none appeared for respondents number private ones,
3, 7, 8.
3, 7, and 8. Who are there?
3 is land, director land management, my lord.
But you are there.
Yes, madam. I'll be appearing for 3 also, madam.
Okay, 3, mention 3, okay, land management. So respondent number 7 and 6 and 7.
7 and 8.
Who are there?
7 is the town planner, Itanagar Capital Complex, and 8 is the estate officer.
Okay, have they been
Your Lordship,
represented?
the affidavit of 6 and 9 will cover their also. Cover them also. Affidavit filed by the 6 and 9 will
You
cover.
have filed for 6 and 9, not
Yes,
5
five-
and 9.
No, Your Lordship. I am
5,
for
6 and 9.
5 to 9, Your Lordship.
There, but she's saying 6. You all are confused and you're confusing me also.
Let me be very clear here. Only 3 respondents have filed so far. Respondent number 4, which is the Director, Department of Housing.
Okay.
Then respondent number 6 is the Deputy Commissioner, Itanagar Capital Complex. Then respondent number 9 is the District Disaster Management.
So maybe 9 has to file?
No, Your Lordship, 6 and 9 we have filed on their behalf.
6
And their
So just be clear who has filed and who has not. You are contradicting each other.
My lord, what government was saying that, my lord, since he has filed affidavit for 6 and 9.
You have filed for 4, 6, and 9.
No, Your Lordship, only for 6 and 9.
For 6 and 9.
And this affidavit will cover
7,
the
8.
contention of 7, 8 also, ma'am.
Okay. 6, 7, 8, and 9.
Yes, ma'am.
Is it?
And I.
So 5 is who?
5.
5 is, the affidavit of 6 and 9 will cover 5.
5. So 5 to 9, it's covered.
Yes, Your Lordship.
They're not going to file. Okay, so
Okay, so
5 and 9. So counter affidavits have been filed?
Yes, ma'am.
No,
Yes,
we
I-
don't have
I-
to wait.
I
Yes.
know that.
Okay. So then we'll cancel so and so. It is submitted that the counter affidavits have been filed by the respondents. Just leave it like that, okay? Are you going to file your reply? You don't have to wait for any more counter. Huh.
okay, so I don't have further info.
Okay,
Instruction.
Then Miss So and so, learned counsel for the respondent submits that next date may be fixed for filing of the reply affidavit, if any, is fixed on.
However, Your Lordship, there's also an interim which may be continued.
Okay, in view of the above list after 3 weeks, meanwhile, the interim order passed earlier shall continue till the next return of date. Yes. Clear.
Right.
So we just mentioned 5 to 9 and 1 to 4 will depend on 5 to 9.
May please, Your Lordship. I am appearing for 1 to 5.
None appeared for the petitioner on call, while Miss so and so, learned government advocate for respondents number
1 to 5.
state respondents number 1 to 5 is present. Yes. Are you filing your counter? Have you filed?
Your Lordship, we have filed already.
Okay, who submits that counter affidavit has been filed by the state respondents. In the absence of the counsel for the petitioner, less after 3 weeks on the dates to be fixed by the registry.
Okay. Your Lordship, affidavit in opposition is yet to be filed.
Okay, Miss So and so, learned counsel for the respondent number,
For all those.
for the respondents submits that they may be given further time to file their counter affidavit. In view of the above, list after, how long will you take? 3 weeks?
3 weeks.
On the date to be fixed by the registry. Yes.
Yes, madam. Respondent yet to file their affidavit.
May I please, Your Lordship? Your Lordship, we need somewhat 3 weeks to file an affidavit in opposite.
Miss So and so, appearing on behalf of the respondents, have prayed for 3 weeks' time to file their counter affidavit. In view of the above, list after 3 weeks.
Interim order, my lord.
Meanwhile, interim order passed earlier shall continue till the next return of date. Item number 23. Yes.
Your Lordship, I have already filed, Your Lordship.
So pleadings complete or what? What is the stage?
Order.
Lordship, I am for the private respondent, 3, 4, 5.
Ah,
I have to file reply. We need some more time, further time.
counter.
Yes, yes.
It's not reply. Reply will be by the petitioner. Okay. Yes, Mr. So and so, learned counsel for respondents number 3, 4, and 5.
Yes.
Okay, has prayed for further time to file their counter affidavit. In view of the above, list after 3 weeks on a date to be fixed. by the
Here is an
secretary.
interim that may be continued.
Is there an interim? Let me see. Wait. In the meantime, interim order passed earlier shall continue till the next returnable date. Yes.
May your lordship. Your lordship, this IA is for file for striking of respondent number 2 from the contempt petition.
Who is the petitioner? Yes. Yes. Who is respondent number 2?
It's the Secretary, Ministry of Road and Transport Highway.
So what is the judgment about? Who is to pay? What?
Actually, it's the GRIP, the BRO department. This road, the subject matter of this road is related to defense, your lordship. Ministry of Road and Transport doesn't have anything to do with this.
Yes, what do you have to say in the IA? Is this the first time it's coming up?
Well, here basically we are responsible for the implementations of the order passed by the Honorable Court. Only implementation is compliance is to make payment. For payment, we are under process for the releasing
You're
of
the one who has to make the payment?
main
Okay, not the
not that,
respondent number 2.
admittedly,
Okay.
So
So
therefore,
petitioner, what do you have to say? I think that's correct, must be correct.
Must be
We'll
correct. Your
strike
Lordship,
off.
I'm not aware of like actually the arguing counsel is in the court number 2.
no issue, some more time may be granted, will comply with the order passed by the Honorable Court for.
Okay, then we'll dispose of the IA.
Yes. Yes, Your Honor.
The IA, this is the IA. IA is that the name. is struck
IA may
off.
be.
Yes. Heard Mr. So-and-so, learned counsel for the applicant, who has prayed that the name of respondent number 2 in the contempt case number 12 of 2024 may be struck off, since the respondent number 2 has no role to play in the compliance of the judgment and order of this court dated 30/01/2024 in WPC 18/2024. He submits that the road in question in the said WPC doesn't fall under the jurisdiction of the applicant. And though the applicant is willing to comply with the court's order, but is not in a position to do so, since it has no part to play for the compliance of the judgment and order. He submits that now Hunli dash Mentendia dash Huyuyan, okay, my pronunciation, comma, Defense Road from kilometer 14300 to 158.00 km, point in both, okay, in Anjao district is constructed by the Border Roads Organization, BRO, which is funded by the Ministry of Defense within brackets MOD, and not by the Ministry of Roads and Transport and Highways, MO within brackets MORTH / respondent number 2. Okay. Having heard the submissions made by the learned counsel for the applicant, and on perusal of the order of this court in WPC so-and-so, this court found it appropriate to that the names of respondent number 2 may be struck off in the instant contempt petition. Accordingly, IA number 115 within brackets AP to 2024 stands allowed and disposed. Registry may do the needful. Yes.
Deeply obliged.
Now, the main contempt.
In main, we are ready to comply with the order passed by the Honorable Court, for which, we'll be required,
2 months time to, my lord, comply, my lord.
Okay, Ms. So and so, learned counsel for the petitioner is present along with Mr. Vato. Learned counsel for the respondents,
Respondent one only, my lord.
for respondent number one. The learned counsel for respondent number one has prayed for further time,
To comply, my lord.
yes, to comply with the judgment and order of this court. So and so in WPC so and so, okay, in view of the above, less after 4 weeks,
My lord. 8
3
weeks.
weeks.
8 weeks, my lord.
No, that's too long. We'll make it 4 weeks,
My
then 4 weeks on a date to be fixed by the registry. Yes.
My lord. Deeply, my lord.
Majority. Yes. Registry, I thought you, yes, anyways,
My lord, my senior, Mr. Tara, is arguing in court number 2. My lord. So they are objecting this morning. Also.
Oh, this morning's thing.
Yes.
So we'll adjourn it then. Mention is made on behalf of Mr. Tara, learned counsel for the petitioner, that the learned counsel is on leg in courtroom number 2. Okay, Mr. So and so, learned counsel for the respondent is present. And matter is adjourned to,
My lord, can it be on 7th of August?
now there was a date which is mentioned, both the
Seven, no.
counsels have to be present, huh?
7 not possible.
Ah,
Already so many cases are fixed on 7. my lord.
Okay, so give me a date when both of you will be present.
Uh,
12 August, my lord.
12th, okay, 12/8/2024, wherein attempt will be made to dispose of the instant, instant CRP, okay, civil revision petition, yes.
My lordship, he's, my senior is lagging.
Yes, yes, just mentioned in the other court, yes. Any other matter? Yes.